Yes, Mr. Anand.
Please, my lord. Chief, may kindly permit me to make a mention for item 10.
Okay.
Item 10, your lordship.
This matter seems to be same. 8 to 10, 8 to 11. Same council, numbers are in seriatim.
Yes, your lordship. In fact, this item 10 and 11, I'm handling these two. I'm yet to receive instruction from the department. So if some time can be granted, my lord.
Who is paying for 8 and 11?
No, 11 I'm appearing, my lord. 10 and 11 I'm appearing. 8, 9 I'm not appearing, my lord.
Now, who is paying? All these things are the same.
Here, and 8 and 9, my colleague AIM is appearing. She's also yet to file counter in this matter. 8 and 9.
So no counters filed in 8 to 11.
Yes, Lord.
Yes, your lordship. In fact, after the motion, this is for the first
These are
time.
matters pertaining to
Lordship,
Retirement,
yes.
retirement benefits, Lordship. Service regulation along with retirement benefits.
17.3.
No, I'm not covered by that, Your Lordship.
You are covered by
Lordship,
16.4.
Lordship,
16.4.
no.
16.9. 2004.
Yes,
Read with the 5.3 2025 or something.
yes, 2004, Lordship.
Because now you have got the scale of pay. The scale of
Some
pay
of the
is
petitioners, they are on scale pay, and then some of the petitioners, they are all
Anyway,
fixed.
we then adjourn this matter, thereby directing them to file their affidavits.
Lordship.
These are all similar matters.
Lordship,
Okay. Item number 8 to 11, same order, huh?
8 and 9 as well. 9 as well.
The council is appearing on behalf of the state. No, all these four matters, the present batch of 4 petitions are filed claiming regularization in terms with the office memorandum dated 16/9/2004, isn't it?
Lordship.
The respondents herein are yet to file their response. The learned counsels appearing on behalf of the respondent state fixed for 3 weeks' time for filing reply. Accordingly, list this matter again on 16th of July 2026. In the meantime, the replies, their response be filed on behalf of the state. It is further observed that pendency of the instant writ petition shall not be a bar on the part of the respondent authorities to consider the case of the petitioners in terms with the office memorandum dated 16/9/2004, if otherwise entitled under law.
Lordship. Deeply obliged.
Lordship. Lordship, I'd like to mention item number 5. Here, Lordship, I've received the counter. On the last occasion, I've sought time for filing AR, Lordship. I'm yet to file, so I pray that a week may be granted, Lordship.
Matter pertains to,
Backlog salaries, Lordship. Payment of backlog salaries.
huh?
Backlog salaries,
Back. Area salary.
Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner may be granted some more time for filing the affidavit in reply. List this matter again on 22nd of June 2026. In the meantime, the affidavit in reply be filed.
Lordship.
Your Lordship, I am appearing in item number 14 from the respondent number 4. My lord, I'm seeking 1 week's time to file my reply.
Item number 14.
Yes, my lord.
What department it is?
Yeah, RCI, Rehabilitation Council of India. Respondent number 4.
The counsel appearing on behalf of the respondent number 4 submits that 1 week's time may be granted for filing the affidavit in opposition. List this matter again on 23rd of June 2026. In the meantime, the respondent number 4 shall file the response on or before 19th of June 2026.
Much obliged. Yeah, much obliged.
Mr. Lord. My lord, in item 7, I've been instructed to appear for respondent 5. In item 7, Lordship, item 7, I've been instructed to appear for a private respondent number 5. Lordship, I may be granted 3 weeks' time to file my reply.
What is that respondent number 5?
He's a private respondent. The petitioner is challenging his her appointment.
Your name has not been reflected.
No, Lordship. I'm appearing today for the first time. I'll be filing my power within 2 days.
Huh?
Yes, Lordship.
Mr. So-and-so, the learned counsel who represents the respondent number 5 submits that he is putting in the appearance today and require 4 weeks' time to file the reply. Have a response.
That is not, Lordship.
Taking into account the above, list this matter on 14th of July 2026. In the meantime, the respondent number 5, as well as the other state respondents, shall bring on record their response. Yes, Madam Anand, you have anything?
Yes, my lords, I'm in item 19.
Okay.
My lords, that is a matter which has come to your lordship, my lords, pursuant to the judgment of this honorable court on 22/4/26, my lords, whereby my lord Justice Budi Habung, my lords, took one view, and my lord Justice Phukan, my lords, took another view. And therefore, it's come to your lordship, my lords, for this consideration.
You are willing to do the matter now?
Yes, my lords, subject to your lordship's lords.
We'll have it in the second half around 2. There are other matters out there. Let me finish the list in the meantime.
Very well, my lords, 2 o'clock then.
Okay.
May please, my lord. My lord, I have a humble prayer on behalf of my senior Ajo. My lord, this morning, one of his cousins suddenly found dead in his bed, so he has to urgently leave for his village. So I pray that his item number 23 and 24. 22 and 23, my lord.
Okay.
He may be accommodated for the petition. Fixed on 9th of June.
What do you say, Mr. Counsel?
I have no objection, Lord.
Is it shown as parted? No, no. Yesterday I heard that matter. These
Yes,
matters.
Then let the petitioner be heard today.
It has been submitted on behalf of the council appearing on behalf of the Lokaयुcta, Nagaland, that the senior counsel, Mr. Ajo, on account of certain personal difficulties, had to rush to his native village, and as such sought for some accommodation. The counsel appearing on behalf of the petitioner submits that he has no objection. Considering the above, the writ petitions stands adjourned to be listed in the 3rd week of June 2026 for hearing.
Lordship,
The
that
matter
may
may
be
be
fixed.
released from parted.
Much obliged, my lord.
There's an Indian, Lordship.
You want a date when? 16th?
Maybe
16 June. 16 June.
Lordship.
Okay. Now,
Deeply obliged.
My lord, on 16 June, my senior, he also have 3 matter in other courts. So, my lord, may it be another date, my lord.
Mr.
19?
Counsel, is your senior advocate?
Yes, my lord.
Fantastic. If he is a senior advocate, you cannot take a time on the ground of a senior. This is the rule of my court. I have permitted you because yesterday the matter was heard. You have a problem, but don't take a time on the ground of a senior counsel. Because the senior counsel is just a daily wager. He appears today, he may not appear tomorrow. Whereas for you, you are an advocate on record. You signed a wakalatnama. Therefore, you are bound to appear in the court.
My lord.
Deeply obliged.
Mr. Lordship, I may be allowed to mention item 15. Here, your Lordship, I have filed the counter But however, with regard to affidavit, bringing on record the acknowledgement received, notice served on respondent number 5 is yet to file. I'm waiting for signature, so this may have to be listed after a week. The counter I filed yesterday. But there's another order from the court to file affidavit bringing on record the acknowledgement received of notice on respondent number 5, which was served by respondent number 4. So I've sent it for vetting for signature.
The counsel appearing on behalf of the state respondent submits that though the response have been filed, but however, another affidavit bringing on account the record the notice receipt have not been filed. Taking into account the above, first, the counsel appearing on behalf of the petitioner submits that she has no objection considering the above lists the matter on 21st of July 2026.
Right, sure.
From the supplementary cost list for motion, item number 17.
Published Lordship. Lordship, here the petitioner is seeking for a direction for appointment on compassionate ground, Lordship, on the demise of his late father.
Whose father died?
The petitioners
When?
on 13/1/2026, while serving as driver under the district supervisor under Mokuchu,
1/2026.
Lordship.
Then? Which department? Health and Family, Kohima.
Under the CMO Mukokchung,
Mokokchung, it's too early for you to approach this court.
Lordship.
You can't approach this court for Mokokchung. If I remember, you will be in number 7 or 8. They will really take note of it. What is there to approach so early? The
Lordship,
father died only in 2026. People who have died in 2016 have not got their jobs.
Lordship.
Too early for you to approach.
Lordship, I have notice be issued. In the meantime, if the state comes to
Now tell me
And-
that your application, when did you submit your application?
on 20th of April 2026.
Then 1 month you have submitted the application. The father died in 2026. How on earth do you say that this court is going to look into this?
Lordship.
He closes this petition with his submission to the effect that he will be considered in terms with the addendum dated 9/4/2019.
Lordship.
Lordship.
This is an application fired Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondents. The petitioner herein has approached this court seeking a direction upon the respondent authorities to consider the case of the petitioner in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. So this court have duly taken note of the facts which are in facts under which the petitioner has approached this court. The record reveals that the father of the petitioner, who was working as a driver at the district tuberculosis center officer Mokokcho, unfortunately expired on 13/1/2026. Thereupon, the petitioner submitted an application on 24/2026. And subsequent thereto, the petitioner has approached this court. In the opinion of this court, that the petition is premature, taking into account that the petitioner's father only expired in the year 2026, in January 2026. And further to that, the petitioner has submitted the application on 24/2026 and have filed the instant writ petition on 25/5/2026. This court have also heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner respondents, who submits that if the petitioner has submitted the application, the same would be duly considered in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. So considering the above, this court does not find the present case to be a fit case for issuance of notice in the present facts and circumstances. Accordingly, the writ petition stands closed. Liberty, however, is being given in the circumstance the petitioner's case is being not considered in accordance with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019.
Yeah.
Obliged, Lordship.
Yes, Mr. Takama, sir, your matter?
Yes. For admission, item number 18.
Sir, yesterday's order made Mr. Im Song appear.
Yes, my lord. He has some serious problems I had discussed with him this morning.
Okay.
Lordship, the issue relates to non-refusal of by the expert committee for revision of the honorarium of the village guards of Nagaland. Lordship, the last case in the last round in the contempt petition, Lordship, contempt petition was closed with a liberty for the petitioners, with the liberty being granted to the petitioners to approach this honorable court to challenge the expert committee report, Lordship. My lord,
There was one petition which came up before me once.
my lord, that was the contempt petition. I'm coming to that.
No, it was another petition filed by Mr. Joshua Seki. Is this the case where they are asking for equal pay with respect to some other officials of the police department?
My lord, in this case, my lord, we approached the honorable court in the early round of litigations that that the petitioners should be paid at par with the home guards. But and then, my lord, because Lordship, because the judgment in the Rakshas state of Himachal case, Lordship, that was the basis on which the revision of honorarium was allowed for the home guards. My lord, may I give a brief background about the case before I come to the issues, because there was an earlier round of litigation. Now, my lord, in that judgment, regularization was refused by the Honorable Supreme Court. But since the home guards were performing a duty of a policeman, when you were performing your duties, in that ground, the Honorable Supreme Court has given a direction that a monthly salary of a village of a policeman should be paid to the home guards of Nagaland, all over the state, all over the country. So relying on that, since we are Ashok Chakra and Mahavir winners, Lordship, and a lot of calendar awards over the years, that has been acknowledged. So we also approached the Honorable Court saying that we are also similarly situated, since we are also performing law and order duties, a duty of a policeman, whenever we are assigned duties, so we also should be paid at par. That was the contention before the Learned Single Bench in the early round of litigation. That was allowed. But before the division bench, Lordship, the division bench notified the order to give a direction to constitute an expert committee. Now, expert committee, Lordship, now here, the fund, the honorarium being paid to the petitioners are recovered from the security related expenditure from the Home Department, MHA. So, my lord, the expert committee was constituted in the first round of the first expert committee was constituted. Then the expert committee consulted MHA, and MHA declined on the ground of fund constraints. So it was rejected. Then we filed a contempt petition. Then in the contempt petition, Your Lordship, it was placed before Your Lordship earlier once. Thereafter, the contempt petition gave a direction to fully comply with the judgment. Then the second expert committee was constituted. But the second expert committee also had reiterated the earlier expert committee recommendation. Accordingly, a contempt was closed, but liberty was granted to us to approach this honorable court to challenge the expert committee report. In the meantime, Lordship, Government of India has filed an affidavit. Now, in view of the Frontier Nagaland agreement, it seems a part of the agreement which was signed on 5/2/2026 at clause 7.2, the affidavit filed by the MHA. It is, Lordship, if Your Lordship may kindly see the MHA, Government of India's affidavit. If Lordship may kindly allow me to read from page 3.
Respondent number?
2.
Yes.
May I read, Lordship, page 3 from B. And next, paragraph 2D. Mayor Lordship, that expert committee held its meeting on such and such in Nagaland. MHA representative attended the meeting through video conferencing. However, owing to probable poor audio and video of MHA representative could not be recorded in the minutes of the above. Therefore, the expert committee decided to take up the matter with the MHA. Governor of Nagaland, by letter dated 17/11/2021, informed that during the second sitting of the committee held on 28/9/2021, it was decided to write to the MHA for its views and comments for enhancement of the honorarium of the village cards. It was also conveyed that committee is of the view that although the functions and natures of the duties of the village cards are quite different from the home cards in practice at times, the village cards under the supervision of district administration and police have been performing various law and order and other security related duties in their respective village areas, and to examine proposals so as to enable the committee to come to a suitable conclusion. The MHA, by a letter dated 14/12/2021, conveyed some observation to the Governor of Nagaland. One, the VGs are basically a volunteer village defense force established by the Governor of Nagaland to help law and order machinery in the rural areas of Nagaland. Except when their services are required, the VGs are free to carry out their normal cultivation practices and other activities in their respective villages. VGs are appointed under recommendation of the village council, mostly to guard their own villages, and are engaged for other duties as and when required. Home guards, on the other hand, are recruited following due process and perform duties on regular basis and can be posted anywhere in the state. As such, VG's claim of parity with the home guard does not appear justified. The MHA, under the scheme of security-related SRA, reimburses 90% of the expenditure borne by the northeastern governments, except Mizoram and Sikkim, for deployment of VGs.
I have read it now.
Lord,
So the question here, I think, which appears to be one, you see, I'm telling you, you have a problem as regards equation. It becomes very difficult for the scope to equate. Except the 1961 or 73 judgment, there's no equation being done, and Bihar, more particularly in Bihar of the Bihar judgment, it becomes a very big problem. But we see a light from the affidavit which has been
Yes.
filed by respondent number 2. Now, the respondent number 2 now takes up that they have entered into some form of an agreement
yes,
for the frontier territory out there, frontier territory.
Yes.
They said. And they are also sponsoring 90% of
Yes.
the amount. So now the question is, when they are presently going into it, looking into this, and when this deployment will happen, now here if you see page 6,
Lordship, yes.
yeah, you see page 7,
Page 7.
page 6, paragraph 2.
Yes,
With regard to the present petition of so-and-so, it is respectfully submitted that the tripartite memorandum agreement between so-and-so
Yes.
is signed on Iman, which entirely includes in clause 7.2 of the year that the frontier so-and-so would upgrade the village guards through a restructuring, recruitment, training, weaponry, etc., in consultation with and the financial assistance of the government of India.
Lordship.
Now, therefore, if that be so, if there is a further, you see, one of the reasons for which they are saying that village guards are actually volunteers who are home guards who are recruited. This is one of the expert committee's decision. And therefore, they have gone into the question of the manner of recruitment as one of the facets for not giving equal pay to that of the home guards. This is one of the elements. Now, with these things which the central government now is going to do, thereby restructure recruitment, training, weaponry, and these will be done, and there will be further financial assistance. Because one of the biggest problems of the state government is the financial assistance.
Lordship.
Now, if the central government gives a financial assistance, it would be better.
Lordship.
So,
Because the government, sorry for intervention, Lordship, in page 7, paragraph 3, in a time-bound manner, that is the statement of the central government.
so if that is so, remain all the clauses we are within a time-bound manner. So we can ask the government, keeping the matter pending, we can ask the central government to look into this aspect.
Lordship, another aspect which I would like to bring to Lordship's consideration. We are not even paid minimum wages at the moment. We are paid, Lordship, an honorarium of rupees 3,000 rupees per month at the moment. Lordship may kindly see what are our entitlement at the moment. Now, my lord, when the expert committee was actively considering the issue, Lordship may kindly allow me to show that the Home Department, the Commissioner Office, that is the Commandant General's Office, put up,
But Mr. Takamasa, I understand that.
yes,
All these things are understood. But if I pass an order out here now,
Lordship.
any order is passed, it may at the end affect the financial assistance which the Ministry of Home Affairs is
Lordship.
thinking of.
Lordship,
So let us now, you see, things have changed after the second committee's recommendation.
Lordship,
In view of this which has happened.
Lordship,
Let us wait for this and ask the government to look into it as to how they are going to take care of these they have stated at paragraph 2 and 3.
Lordship.
I think that would be better for
Lordship,
the time being.
Lordship,
keeping the
fine.
matter pending.
But then
Because the state would not have any problem in giving you the minimum wage or whatever wage. But the only problem is the state has no money. This
Well,
is the only problem which they.
my respectful submission at this moment is that it lists in observation may kindly be made that we are not even paid minimum wages at the moment.
So that I'll observe it,
Lordship,
that now they have stated in this affidavit.
Yes.
So you have challenged, but things have not changed.
Lordship, I agree.
So in view of the filing of the affidavit by the respondent
Lordship.
too, things have changed.
Lordship.
So therefore, now there will be a requirement to have an overlook when there is a further financial assistance and more particularly through restructuring, recruitment, training, weaponry.
Lordship,
So if that be so, if it is being done, there will be a necessity. And taking into account that the minimum payment of minimum wages is one of the necessary requirements of the minimum. Now you have the Code of Wages Act.
Lord, my lord,
Now we have the Code of Wages Act.
Lordship, yes. Actually, I wanted to raise those issues today, but then since your lordship has looking at the larger picture, I'm not going deep into all that today. But lordship, just bear with me to go to page 22, how we are regretted. I want to add one, your lordship, I would like lordship to see a paragraph at page 22 of my writ petition, the office memorandum, how we are regretted.
Yes.
Lordship, I'll read the first two paragraphs only. Well, it is observed that there is no prescribed procedure for recruitment and discharge dismissal of government sepoys in where there is a requirement to maintain uniformity in such matters in respect of all village guard establishment in district. Therefore, the following guidelines are hereby notified for compliance in matters concerning recruitment and discharge of dismissal of sepoys. Recruitment of VG sepoys in the VG organization shall be under recommendation of the respective village councils. The name of the interested candidates will be submitted to the village commandant, deputy commandant, district assistant commandant of the concerned area, who in turn shall recommend for the appointment of the commandant VG, deputy VG, such and such in the respective district, who shall be the appointing authority. 2, my lord, this is what I'm confirmed. As sepoy being appointed in the organization, shall serve the organization for a minimum of 10 years, failing which FPF, LIC, and other benefits will claim to have been forfeited by the concerned sepoys. Well, just then, Lordship may kindly allow me to refer a paragraph in the writ petition, paragraph 3.
No,
And-
no, Mr. Tagaman, I understand that. Here there is a method, and if you don't work for 10 years, then also you would not be. And apart from that, when you have a power to dismiss,
Yes,
there is a power to appoint.
exactly.
And when there is a power to appoint, there is also a thing that there has been a recruitment.
Actually, and
It is not a case
also
of
my,
voluntary.
so in paragraph 3, my contention was for all practical purposes, I'm treated as a regular employees of the state. That has not been denied by the state government in the affidavit. That I would like to highlight, because Lordship, most of them, almost all of them, after being appointed, my lord, they serve after 35 years or 60 years.
No, understood. So therefore, as of in view of the affidavit filed by the respondent number 2,
Lordship,
where the union government who is financing 90% for the
Exactly.
voluntary BG, therefore, And there is an active steps being taken by the respondent number 2
Lordship,
in terms with the agreement dated 5/2/2026.
Lordship,
Then we ask them to look into your case.
Lordship,
And keeping in mind that payment of the minimum wages
Lordship,
is the mandate of law.
Lordship, Lordship,
And keep the matter pending.
Lordship, yes, Lordship, yes,
I think that is a better.
Lordship,
Because as of now, that recommendation has lost its efficacy,
exactly.
taking into account now the stand which is being taken.
In fact, it's a positive development for me.
Yes. Heard Mr. Takamasa, the Lily Senior Counsel appearing on behalf, Lily Senior Counsel appearing, assisted by so appearing on behalf of the commissioners. Yes. Mr. Gauhati appears on behalf of the respondent number 2. Respondent number 2. Mr. Intim Song, the learned additional advocate general appears on behalf of the respondent number 1, 3, 4, 5, and 6. The present petition has been filed by the Village Guard Association of Nagaland, which is a registered association. In the same association, there are 9579 personnels working.
Lordship, kindly bear with me there. In the latest government of Union of India affidavit, it is written, presently the total strain is 8,206.
But that is what you.
Yes, initially when I approached this court.
It's okay.
Okay.
The same association represents all the village guard personnel, which is about 9579 serving under the government of Nagaland as on the date of filing of the petition. The petitioner association have challenged the recommendation made by the report of the reconstituted expert committee dated 4/7/2023, and further have sought for direction for payment of the minimum wages in respect to skill category to the members of the petitioner association with effect from 14/6/2019. In addition to that, the petitioners have also sought for a direction upon the respondent authorities for regular scale of pay in terms with the notification dated 5/3/2025 and the office memorandum dated 5/3/2025. The primary challenge in the instant petition is the expert committee's recommendation dated report dated 4/7 4/7/2023, whereby the committee so constituted were of the opinion that the members of the petitioner association would not be entitled to the equal pay for equal work vis-a-vis the home guards employed by the state of Nagaland. First, Mr. Takamasa, the learned senior counsel, submitted that the basis which were taken into consideration by the expert committee, so constituted in the report dated 4/3/2023, appears to be are fallacious in as much as various important aspects were not taken into consideration. The learned senior counsel submitted that the expert committee in the case of recruitment observed that while home guards are recruited, the members of the petitioner association volunteer, which on the face of it is incorrect, taking into consideration the office memorandum dated the office memorandum dated 10/1/2013, which categorically mandates as to how the recruitment would be carried out and what is the minimum required service to earn benefits. The learned senior counsel submitted that when the person can be dismissed or discharged, as would be seen in clause 5 of the office memorandum dated 10/1/2013, it implies that there is a recruitment, in as much as without a recruitment there cannot be a discharge or a dismissal. In addition to that, the learned senior counsel submitted that various other aspects which have been taken into consideration are not, in addition to that, the learned senior counsel submitted that various irrelevant considerations were taken while making the report, impugned report dated 4/7/2023. The learned counsel submits that when an irrelevant consideration is being taken, the report on the face of it becomes unreasonable, as it would not satisfy the requirement of the principles of Wednesbury's reasonableness. Be that as it may, it is the submission of the learned senior counsel, but that there has been certain subsequent events post the report which would be apparent from the affidavit filed by the respondent number 2. The learned senior counsel have referred to the various paragraphs of the affidavit in opposition filed by the respondent number 2, wherein it is categorically mentioned that the Ministry of Home Affairs, under the scheme of security-related expenditure, reimburses 90% of the expenditure borne by the northeastern governments for deployment of village guards for security duties. Despite, it is also mentioned that the Ministry of Home Affairs have also, pursuant to the tripartite memorandum of agreement dated 5/2/2026 with the government of India, with the government of Nagaland and Eastern Nagaland People's Association, have incorporated a clause, being clause 7.2 in the memorandum of agreement, wherein the Frontier Nagaland Territorial Authority would be modernized and the village guards would be modernized and upgraded, and the village guards through restructuring, recruitment, training, weaponry, etc., in consultation with and financial assistance of the Ministry of Home Affairs. It is also mentioned in the learned senior counsel also mentioned that upon the signing of the memorandum of agreement, steps have also been taken in terms with clause 7.2 for upgradation of the village guards of the Nagaland as had been stated in a time-bound manner. First, he therefore submits that in view of the recent development which took place, as would be seen from the affidavit in opposition filed by the respondent number 2, the things which became the aspects which were the basis on which the expert committees, the impugned report of the expert committee dated 4/7/2023 were taken into consideration, no longer survives. This court have also heard the learned counsels appearing on behalf of the state respondents as well as the central government. From a perusal of the affidavit, so filed by the respondent number 2, it is seen that there are certain developments which are being taken up on the basis of the memorandum of agreement dated 5/2/2026. In this regard, this court finds it relevant to reproduce paragraph number 2, 3,
Lordship, up to 5.
4, 5 of the affidavit filed by the respondent number 2. From the said affidavit, it is therefore seen that the Ministry of Home Affairs, the Government of India, are taking active steps in consultation with the state government, as well as taking steps with the state government for the purpose of modernizing or upgrading the village guards through restructuring, recruitment, training, weaponry, etc.
Financial assistance of the government of India, Lordship.
In addition to that, there would be further financial assistance to be made by the Ministry of Home Affairs. First, considering the above, this court, and further to that, it is also mentioned that paragraph number 3, as above quoted, that clause 7.2, that the memorandum of agreement, including clause 7.2, would be implemented in a time-bound manner. Considering the above, this court defers the adjudication of the instant writ petition for a period of 2 months, so that an update can be placed as regards the steps taken for the implementation of clause 7.2 of the memorandum of agreement dated 5/2/2026. Before parting, this court, however, finds it very pertinent to observe that it is the mandate of law that the minimum wages has to be paid. However, it is disheartening to note that the village guards, as on date, are not being paid the minimum wages, at least the minimum wages. This court expects that the government of India, as well as the state government, shall consider the same while implementing clause 7.2 of the memorandum of agreement dated 5/2/2026. List the matter again on 17th of August 2026 for an update.
Much obliged.
An affidavit be filed on behalf of the state respondents by the concerned official of the state respondents in that regard.
Much obliged.
Because this is, if I say anything or put anything, this may stop 7.2.
Lordship.
Let us take it, let us.
Lordship, I'm very obliged to you, Lordship. It will have good, many villagers will have good trips.
You see, the problem is with the judgment of the Supreme Court in Bihar struggle, Teachers Association have made it very difficult to give the equal pay for equal work. Because they have in paragraph 100 postulated various points, and more particularly the concurring judgment of Justice Sapre further says that even it goes to the extent to say that Jagjit Singh did not consider this point as regards the recruitment, source of recruitment.
My lord, in this case, in the earlier round of litigations, what I was stressing on was the paragraph 39 of the Raksha judgment, which is relied by the Supreme Court. Because the only issue to be determined in my respectful submission is whether the petitioners are also performing law and order duty of a policeman while performing their duty or not. Because in that particular judgment, the Honorable Supreme Court did not go on to the issue of equal pay for equal work. The only consideration was whether they are performing the duty of a policeman while performing their duties. On that ground,
Understood. But Mr. Tagamatsa, if you see the Bihar judgment 2018-19 SCC, there were two sets of teachers.
Lordship,
One was a teacher who was appointed in a particular scheme,
Lordship,
and one was the regular teacher.
Lordship,
They do everything same.
Lordship,
Everything was same if you see the last.
Lordship.
But the board say that their recruitment, source of recruitment is different. And therefore, they cannot be equated.
Lordship.
Yes, it is. And therefore, and further went to say that in Judge Singh, because otherwise Judge Singh really takes care of it,
Yes.
which says that did not consider two constitutional bench judgments of 1954 and 65. That is one. But one has to also, with due respect to the Supreme Court, one has to also take into consideration that at one point of time, it was only the services of the government which was available. Now, in view of the various plans,
Yes.
just for example, the 5-year plans and
Gotcha.
all, which requires that apart from all other aspects, there will be various schemes for developments. Now, once these schemes for development become a part of the ongoing business of the government,
Exactly, Lordship.
then you cannot later on say that it is not so.
Lordship.
So this is a thing, I think there is a difficulty, we can't help it, it's a Supreme Court judgment.
Applies.
For admission, item number 1.
Yes, what is it?
Lordship, yes,
Passionate appointment.
yes, Lordship. On the last occasion, that is on 23rd of March 2026, direction was given to show the place relevant documents.
You seem to be expert with compassionate appointment.
No, Lordship.
Then, this is the second matter. I'm taking up 3 matters till now. Out of 3, he has appeared in 2. And the second matter of his, in these 2 matters, both are compassionate. You have beaten Mr. Sentiander. Okay, what is this? What is the status, madam?
Lordship, here, the petitioner's post has been now phased out by the central ministry. The post that was held by the petitioner is already phased out by the ministry. Now, the department has put up to the government to take over and make it an in-cadre in the state post.
Okay, normally.
Because, yes, so it is put up in the cabinet, pending before the cabinet, Lordship. That is the present position, Lordship.
But why is he asking for compassionate appointment? This is a case, I think it's a wrong matter.
Lordship.
This is a case of compassionate appointment.
Lordship,
You are asking for compassionate appointment in terms of 17/9/2015 and 18. Now, what is his status? Whether his father was serving in the government, mother was serving and as typist
Yes,
in the Department of Social Welfare, one son.
yes, Lordship.
Then,
So initially, she was appointed in the ICTS project, but it was made transferable, Lordship, into the state post as well as the ICTS.
but he is not coming within the
No, Lordship.
regular services of the government. Then if it is not so, let us see this office memorandum. This office memorandum is only applicable to those persons. Kindly come to Annexure 5. In supersession of the department, SOA even member dated governor is pleased to revise the existing scheme for appointment on compulsory of family members of government, state government employees.
Lordship.
He's not a state government employee, his mother.
So at this juncture, the petitioner.
Then how can he apply under 17(9)?
Lordship.
No. You may bring the post later on.
Lordship.
to the services of the state by a
Lordship.
process of normalization. But this is subsequent.
Lordship,
As on the date on which his mother was at IPH, she was not a part of the state
State
government
force.
employment. So
Lordship,
therefore, he does not get it.
Lordship,
Take up that argument.
Lordship.
Lordship,
What the argument you are placing is the government will consider this post and normalize and drawing it, it's a plan post.
Lordship,
It will be brought into the state plan.
yes, Lordship.
When it is being brought into the state plan, it becomes a part of the revenue expenditure of the state,
State of
isn't it?
Lordship,
As of now, it is under the planned expenditure.
Exactly.
Against the 5-year plan, 10-year plan, or the central, when it is mostly a centrally sponsored scheme.
yes, Lordship.
ICTS was a
Yes,
centrally
Central
sponsored scheme.
9010.
So when a person works for a long time, an office is there for a long time, it would then be brought within the status of the state. But as of now, it has not.
No, Lordship.
So if it is not, or at the time when his mother died, she was in the plan post, which was not a state government employee.
Yes,
Then
Lordship.
how can he get the benefit of this?
Yes, Lordship.
No, he can't. That case,
yes, Lordship.
the second dismissal.
On that line, Your Lordship, on that line in the affidavit, they've stated in para 7 and 8. May I take you, dear Lordship?
Ah.
If direction may be given in this line, Lordship.
Huh?
Affidavit in the position of respondent 3, 4, and 5. It para 7, the next page, paragraph, page 4, on the second paragraph, Lordship. In this regard, it is to be made clear that the petitioner teaches mother store funding and limited only to certain posts. Therefore, considering the requirement, the department is initiated necessary steps requesting the government of Nagaland for adoption and utilization of the different section of posts, including the LDA post to be absorbed in the state cadre for which the exercise is under process.
Good.
Yes,
So therefore,
Yes,
as
Lord.
on that day, your mother was not within the fold of a state government employee when your mother died.
Lordship.
So therefore, how can you become, you will be entitled under 17(9) unless and until 17(9) says that any other post,
Yeah.
it only specifies as regards the state government.
Yes, Lordship.
You will file an additional,
Lordship.
okay,
Lordship.
on that. Or should I dismiss his petition?
Lordship.
I dismiss your petition.
Lordship, if direction may be given on the basis of your paragraph 7 in it, Lordship, then I don't have
Paragraph
objection.
Tell about that. As of now, we will not. You see, kindly see what is page, kindly see this.
Lordship, yes, I'm aware.
No, because tomorrow they may say, these NHM people,
Lordship.
a person, if we allow this type of petitioner, madam, you do know what is the effect of it?
Lordship.
NHM, just for example, NHM. A person who works in the NHM, he dies, he person comes and files an application.
Yes, Lordship.
And then he will be, you have to give him under the compassionate appointment.
Yes, Lordship.
Can you give it? No.
No.
Then I think we should dismiss it right away.
Lordship. If I may, my Lordship. Lordship, here they have stated that if the state government considers and approves the proposal for
Forget about
adoption.
what they say, Mr.
Lordship.
Counsel. What is the compassionate appointment? A compassionate appointment is not a source of recruitment. Isn't it? Do you
Lordship.
accept or not? It's an exception to Article 14 and 16. Do you accept it or not? If it is so, you are to fall within the parameters within which the government is doing it. The government says that, look here, these are our employees. And is these are our employees, we do one thing. There's some bread earner had died, the sole bread earner, so then let us do one thing, give a job to anybody out there. That is the basics of compassionate appointment. Now here, your mother was never a government employee. Then that is the requirement. And if you don't fulfill it, it cannot happen. Be dismissed.
Lordship, if I may.
If he tomorrow also it becomes a state government employee, that post,
Yes, Lordship.
it will happen subsequently.
Exactly.
So it cannot be. There is a difference between Therefore, tomorrow many people will say, okay, you are giving it to a regular government employee. Somebody will say that, okay, 17/3/2015 is there. 30 years thereafter, my mother or father would have become regularized, become a part of the state. If he had leave, so kindly give me compassionate appointment. Are you going to give? No.
Then, Lordship, a chance we begin to file in petition
That
immediately,
is-
Lordship.
What do you say, Mr. Angami? Huh? You are against an expert of compassionate appointment. What do you say?
Yes, the policy of the government has to be followed, Your Lordship.
No, this is very difficult if you are
Yes.
doing it.
Yes.
Yesterday, I passed an order asking the chief secretary to file an affidavit as to why different departments were having different policies.
Correct.
One department says that we are going to maintain a district. One department says that we are going to do everything. It cannot happen. It has to be one.
Yes, yes, that's the one.
The commissioner and secretary of the power department thinks, no, we will do it this way. And the commissioner and secretary of the health department says, no, we are going to do as per the district ones. That cannot be.
No.
There has to be a uniform as to whether you are going to make it district or so and so. So therefore, we dismiss it. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent numbers 1 to 5.
345, Lordship, standing counsel for 345.
Why? Not others? Oh, you are there. So government is now bifurcating. Appears for the respondent numbers 3, 4, 5, and he appears for respondent number 1 and 2. The petitioner herein is claiming, has filed the instant writ petition. The petitioner herein has filed the instant writ petition, seeking a direction upon the respondent authorities to consider his case in terms with the office memorandum dated 17/9/2015 and the addendum dated 9/4/2019. It is the case of the petitioner herein that the petitioner's mother was appointed as a typist and posted at Wansang in the office of the district welfare officer, Wansang, Nagaland. Under the establishment of the Directorate of Social Security and Welfare, Nagaland, Kohima, in the scale of pay. The mother of the petitioner expired on 26/2017 while serving under the department as a typist for 18 years, leaving behind the petitioner and one daughter. The petitioner thereupon submitted an application on 4/7/2017 in terms with the office memorandum dated 17/9/2015. It is the further case of the petitioner that the petitioner is a BA graduate from Northeastern Hill University and holds a diploma in computer application. However, as the petitioner's case had not been considered, the petitioner had approached this court by filing the present petition. This court duly takes note of that the respondent number 5, 3, 4, and 5 has filed an affidavit in opposition, wherein it is mentioned that the appointment of the mother of the petitioner was to a centrally sponsored scheme that is, what is full form? That is the Integrated Child Development Services. It is further mentioned that the same post of the petition, which was held by the mother, is still not brought within the state flag of the state, meaning thereby it is yet to come within the ambit of the state employment. It is further, in addition to that, at paragraph number 7, it is mentioned that recently the central government have stopped the funding for 319 posts. And the state is in active consideration to bring those posts, including the post which was held by the mother, within the fold of the state employment. First, this court have also taken note of the appointment of the mother of the petitioner, which is Annexure 1 to the petition. A perusal of the appointment order categorically mentions that the appointment of the mother of the petitioner was coterminous with the central government scheme, which was emphasized in the Government of India's letter dated 24/2/1997. It was also mentioned that the appointment was of the mother of the petitioner was liable to be terminated in the event of discontinuation of the centrally sponsored ICTS scheme funding by the Government of India. In that perspective, this court finds it relevant to take note of the office memorandum dated 17/9/2015. The relevant portion of the said office memorandum being pertinent to the decision, pertaining to the adjudication of the instant dispute is reproduced hereunder. Madam, you'll find it at page 19. I have put it with pencil and put a cross mark that area. Okay. From a perusal of the above quoted portion of the office memorandum dated 17/9/2015, it is mentioned that the scheme for appointment on compassionate ground is available to family members of state government employees who die in harness. The mother of the petitioner was not a state government employee, inasmuch as she was appointed against a centrally sponsored scheme. This court now finds it very relevant to take note of that appointment on compassionate basis is not a source of recruitment. In fact, appointment on compassionate basis is an exception to Article 14 and 16 of the Constitution. It's a policy of the government to provide succor to the members of the family of a deceased government servant who was the sole bread earner of the family. Taking into account that the appointment on compassionate basis is an exception, the mandate, the policy in India, the claim for appointment on the compassionate basis has to strictly fall within the parameters of the policy. In the instant case, the policy office memorandum dated 17/9/2015 stipulates that it is only available to the state government employees. Considering the above, as the mother of the petitioner was not a state government employee at the time of her unfortunate demise, it is the opinion of this court that the petitioner is not entitled to be considered in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. Taking into account the above, the instant in view of the above analysis, this court does not find the present case to be a fit case for issuance of a writ, for which the writ petition stands dismissed. However, no costs.
Publish, grateful lordship.
For admission, item number 2.
May I plead lordship?
Oh, yes, tell me, Mr. Turian.
Please, lordship. Lordship, I was also observing the court proceeding. The
Where?
matter is with item number 18, our senior advocate, Sir Takamaka case.
Yeah.
Here, the matter is again, your lordship, relating to equal pay for equal work.
This is for you are village guards.
Lordship,
Huh?
lordship.
No, you are not village guard, you are teachers.
Yes, yes, lordship.
How are
I'm a
you
teacher.
that this matter is same with Mr. Takamasa's matter?
No, no, lordship, I was saying that relating to item number 18, when your lordship was saying all those judges in case, that Bihar case, I was also listening there because my subject matter is also similar.
So before starting, you are saying that you are conceding. Are you conceding before even arguing? Anyways, I'm very bad in respect to equal pay to equal work. Let it be next week. You'll have a kinder judge tomorrow, next week. Okay?
Lordship.
Better off.
Lordship, here the matter is very,
Mr. Counsel, don't interest this court to enter into the merits.
Lordship.
If you have, it's a case of equal pay for equal work, you have a very big difficulty. Let's see. If you want, I can very well. You do it at your own peril. Let's see. Direct to regularize the substitute GT appointment post into the regular appointment. Oh, yeah, you are asking in terms of the minimum scale, minimum work, what do you call minimum scale of pay?
Lordship, which former
Mr. Counsel, prayer number 1 and 2, I can't give you.
Lordship, that has already been,
I can't give you, taking into account what you are asking that the state should use this post or make it regular and all, that is absolutely within.
Okay.
Now, you are entitled to the minimum scale of pay or not, that is a question which this court can consider, that prayer number 3.
first order itself, your lordship, in the motion that has been reflected, I have foregone all the prayers, except that I am discharging similar duty which Sri Kompang Aunok was discharging.
So therefore, you mean to say that you should get the minimum scale of pay?
Yes, which in place where I have been appointed, which Sri Aunok was receiving. That is my only limited prayer, your lords. Because I have been appointed as a substitute teacher in place of Sri Kompang Aunok. Now he has been
now tell me one thing, wait. Tell me one thing, how do you take care of that office memorandum dated 5/3/2025?
Lordship, my case is before that memorandum, your lordship. I have been appointed
as of today, 5/3/2025 has come in.
Lordship.
Have you left, are you still in the job or not?
Yes, I'm still in the job, lordship.
So therefore, why are you not improving your case with 5/3/2025, saying that now everybody is being given scale of pay? So when you are being given the scale of pay, it has to be the minimum scale of pay. Your repetition will be automatically allowed. Come up with that. Now you see, anybody who has this RIA in the PIMS or something to that effect, what is that, 5/3/2025? Isn't it say that a person who has been there in the fixed or anything, they will be given this, they will be granted the scale of pay
Lordship,
as of 1/1/2025,
yes, Lordship,
1/4/2020.
yes. Lordship, one thing, the difference between the present case, petitioner case with the other case is that petitioner has come before this court praying for equal pay at par with other ad hoc employees. Now, in terms of the judging case, whereas,
Understood, but
yes, whereas one,
understood. Now, first of all, they are getting fixed pay.
yes, one difficulty the petitioner has here is he doesn't, she doesn't possess the basic professional qualification, that is B.Ed. So,
No, recently, this is in which school?
governmental school Chamfor.
What school is that?
Middle school.
So you don't require the TET qualification.
No, she needs. She's a graduate teacher.
You don't require TET.
No, she needs B.Ed. That is.
No. Nowadays it has been mandatory to may have the TET qualification or something.
Yes, yes. That maybe not be very necessary, but the basic B.Ed.
So why you are saying that she doesn't have the qualification?
She doesn't have.
What does she?
Which she needs to work with.
Lordship,
Ah.
I will like to draw the attention of this honorable court. When this matter came up on 12/2/2026, Lordship, when this honorable court asked the learned government council, why you are not giving me that scale of pay? He said, because I am not possessing that B.Ed degree. According to this honorable court has directed the state respondents, whether all the ad hoc employees or any employee under the same establishment possessing that same B.Ed degree or not, and accordingly state respondents has directed to place the record before this honorable court. But till date, your lordship, the state respondents has not did that. So if, and even in my additional affidavit, I have filed your
Mr. Suryan, you are claiming negative equality.
Yes, Lordship.
Lordship, my specific only claim is that
It's a different thing. That person has appointment is wrong. They have done some legality, but does it entitle you to get it? Very difficult.
no, Lordship, I am only saying that Sri Tompang Aunok was getting, since I have been substituted in place of him. So what salary he was getting, at least I should get that salary, because I am discharging the same similar duty.
First of all, do you have the qualification to be there? B.Ed and TET. That is why I asked you.
Yes, B.Ed, yes. That
you have categorically mentioned in the order.
Yes, yes,
in
Lordship.
12.2, you said it required TET.
yes.
And you see, Mr. K. Angami, the learned senior government advocate, submits that in terms of the recruitment rules in force, graduate teachers are to have B.Ed degree along with TET for appointment as graduate teacher. Therefore, I asked you. that.
Yes.
Now, recently, the Supreme Court came up with the judgment out there. Recently, I think 2-3 days back, I think it's the judgment of Justice Dipankar Datta to that effect, where he said that without this qualification, he cannot be in the job. You putting him, you should throw the petitioner. Petitioner should not be there in the job. This is a very recent judgment, I think 3-4 days back. If he is employed, that means the state today is employing persons to teach the students by a person who is not qualified. This is very serious.
Lordship,
Very serious. I think your job should go. Forget about
Lordship, I will just like to mention in that respect, your Lordship. Number one, your Lordship, as your Lordship is saying that if I am not possessing that qualification,
You have
no
the
doubt, your Lordship, that Sri Tompang Aunok, who was appointed as employee.
Mr. Suryan, Do you have the qualification to be a graduate teacher or not?
Lordship, I am a graduate teacher, Your Lordship. But
Do you
I
have
don't.
Do you have the qualification to be a graduate teacher or not?
Lordship, I am a graduate teacher, Lordship.
No, you are a graduate teacher, I'm not on. But I'm asking you, do you have the qualification to be a graduate teacher? There's a difference. Government have illegally appointed you as a graduate teacher is a different thing from the fact that whether you have the qualification to be a graduate teacher.
Yes, Lordship, I have.
Okay, well,
Only,
let us see the qualification of a graduate teacher. Where do I find it?
Lordship, that I have not enclosed in my petition. If Your Lordship may allow,
No, Mr. Suryan, initially I state to you, don't interest this court with the merits. Once I enter to the merits, then it becomes very difficult to leave it halfway. Isn't it, Mr. Andami?
Lordship.
What is the qualification of a
Lordship,
graduate?
my affidavit, page 18, Annexure C. It
Page
is
18.
Yes, Annexure C. Nagaland School Education Service Rules 2017. Then the relevant portions.
Page 18.
Yes, the relevant portions at page 20, Lordship.
National School Education Service Rules.
Yes,
This is here. Then graduate teacher, where is it?
page 20, Lordship.
The required education, the graduate teacher, postgraduate with postgraduate with at least 50 marks or equivalent, relaxable by 5% on a year, so and so and so and so. Bachelor or better. And besides fulfilling the above, the candidate must have cleared the state debt conducted by CRT. So you fulfill what are the requirements in clause Roman 2, B Roman 2, 7B Roman 2.
Lordship, first of all, at that time when I was appointed, this was not there. This was passed in the 2017 only.
No. My question is, Mr. Counsel, when you were appointed is a different thing. You can give your TET at any point of time. There's no
Lordship.
problem. But you don't have the TET.
Lordship, in that respect, at least state government should advise me or issue notice me that you don't possess that qualification. Accordingly, I will do.
You should be happy that they have not informed you. If they have informed you, it was their duty to remove you. In fact,
Lordship,
that is why I said that in the recent judgment where the review was filed, Mr. Angami,
Yes.
go through that judgment.
Lordship.
Where a review was filed as to whether these people will require qualification, what will they file a review? Then look here, at that point of time when we were appointed out there was no requirement. And later on, therefore, they have brought in all these things. And therefore, the matter went to Supreme Court. Supreme Court said no, and thereby gave some extension that within this particular period you have
5
it.
years, Lordship.
5 years, and if you don't have it, you have to be chucked out.
Yes, Lordship.
Now, thereupon a review was filed. Recently, the review, I think 4 days, 3-4 days back, Supreme Court dismissed it. I think on 26/5/2026, had dismissed it, saying that no person can be employed. In fact, your appointment, if you don't have this qualification which is required, goes against the Right to Education Act.
Lordship. Yes.
Lordship,
Your appointment is in violation of Article 21A.
Lordship, during that time, this
Article 21A is much important. We have to
Lordship,
think about the generation, the future. So we need to dismiss your case with cost for spoiling environmental degradation for filing so many pages.
Lordship, what I am saying,
Yes.
when this state respondent issued that notification, prior to that, before 5 years, I was appointed. So if state government had any issue with my educational qualifications, then at least.
No, Mr. Counsel, for being, you are asking for regular salary of a graduate teacher and you don't have the qualification.
Lordship, I'm a teacher.
No, you don't have that.
No, definitely, I didn't pass that.
Mr. Counsel, you are not understanding. If I hold it that you are not entitled because you don't have debt, the
Lordship.
next thing is the government will throw you out.
Lordship,
You get the point?
Lordship. Yes,
Now,
Lordship.
The
Yes.
best is to keep quiet and do your job and get after some time a particular the TET qualification and come back. And TET can be given at any point of time. There is no age bar.
Lordship,
Come to them, Mr. Counsel, Mr. Suryan, if I hold it and say I dismiss it on what Mr. Angami has stated in his petition, the next action is that as you don't have that, it will come up on black and white. It will be now record. It will be a part of the public record. They will be bound to throw you out.
no, Lordship, what I'm saying, if that is the view of this honorable court, then I'm praying before this honorable court that in the meantime, if I can qualify that exam.
Obviously, you come.
Yes,
Liberty, I'll give you. As of now, say that
maybe
I also don't want to use the word that once you qualify, because if you say that that will again be anyways. I think better off that you say we close this petition with an observation that in the circumstance the petitioner is qualified. Would not say that dead.
No.
Qualified, he can again approach the court.
Lordship.
Better.
And in the Lordship, if this court can also be directed the state respondent to, after qualifying, my application may be considered by the state respondents.
You are yet, Mr. Counsel, you are yet to fill up the form also.
Lordship.
Me to say that I will pass an order that you will fill up the form, appear in the examination, and prior to that you will study and appear in the examination. You will pass out. Then they should consider. Why?
No.
I don't, Mr. Counsel, I'm not a fortune teller to tell you to qualify today. No, that order, you want a consideration which is yet to be born.
Lordship, in case, in future, if I qualify, then if I make a representation before the state government, then the state government may consider my representation.
So another thing now, after appearing in the examination, you qualify and then submit a representation, then they will consider. This type of orders I don't pass.
Lordship, one more thing, the petitioner is even yet to clear B.Ed.
B.Ed is also not there.
Not there, Lordship. So at least that is 2 years, 3 years. So
Lordship, in that matter, please may kindly go through my edition.
Mr. Suryan, I'm coming back in 5 minutes. Where is my colleague? Akash, 5 minutes, you just think about. I don't think I would not allow you. I'm not going to pass an order which is not born even in the embryo. Once it is born in the embryo, I may consider. Not now. It is yet to be born. The marriage has also not happened. So till now, nothing is there. I'm coming back.
Lordship.
So your, Mr. Counsel, you will come back when you obtain your degree. B.Ed
Lordship,
and Tech.
before the Lordship, I want to submit something.
Hmm.
Lordship, I don't know whether this honorable court has gone through my additional affidavit or not.
Hmm.
At paragraph 5 of my additional affidavit,
Hmm.
shown along with
What do you
my
say?
additional affidavit, paragraph 5.
Paragraph 5 of your additional affidavit is your
Lordship.
statement.
Lordship, there I have stated that one person by the name Sri L. Arthun Imchungar. He was also appointed as a substitute teacher. Later on, he was converted as ad hoc service. No doubt that is not my prayer, Your Lordship. But here, what I mean to say that isn't it amounting to discrimination? Why only this treatment to me, Your Lordship? Because on the last occasion, when I said, Your Lordship, on 12 to 2026, the Learned Government Council has said that all the other ad hoc employees, they are possessing this B.Ed degree. Accordingly, this honorable court has directed to place on record, but till now they have not done that. So this is not the case of discrimination, Your Lordship. Why only this treatment to me? There are also many other ad hoc employees who are not possessing this B.Ed or TET examination degrees, but they are getting salary much far than me, though I am giving my similar service as of those other ad hoc employees.
So you want a dismissal then?
No, Lordship, I am just bringing to the knowledge of the Honorable Court that
Absolutely, I am not going to touch other people unless somebody comes up before this court against them, not against this. Not at your instance when these people have not been qualified, not been made parties. My question is therefore we dismiss you as per the Bihar struggle, one. Or we dismiss you on the ground that you should not be at all be there at all because it violates Article 21A of the Constitution, as well as the judgment of the Supreme Court wherein it says that the TET or minimum qualification which is there has to be there for becoming a teacher. So therefore, the government should not keep you at all. We ask you to remove him.
Contemplating to advertise the post.
Yes, you should advertise a post because of the fact that he cannot, under any circumstances, continue in this job if he does not have the educational qualification. I'll give you the release.
Lordship,
Let me give you the recent judgment in this point. Dismiss your petition. This is the judgment I told you, na? 29th of January, May 2025. The relief which was the review which was sought for, and this is the case, it may at this point be relevant to remind ourselves that the law must also be strived to be pragmatic. Reference can profitably be made to the decision of this court in state of Nagaland, but has held that in cases where substantial justice and technical were pitted against each other, a pragmatic approach should be taken with the government. Though this observation was made with regard to the condonation of we may so and so. Does the concern that the teacher could likely get displaced in the interest of children being rendered a casualty merit consideration to an extent? While the requirement of qualifying threat cannot be diluted in its rigor, we cannot remain oblivious to the practical repercussions that may ensure if a substantial number of insiders put due to the possible loss of their employment with truncated time frame, thereby adversely. Having regard to the paramountity of the ensuring continuity in elementary education, we deem it appropriate to grant limited leave by extending the period earlier stipulated for acquiring the TET qualification again in exercise of power under 142. Appreciating that the TET examination must be conducted by the relevant authorities expeditiously, as well as the time and resources required for the same are limited, we alter and extend the time limit of 3 years in paragraph of 1 for the teachers to acquire the TET qualification for 2 years to 3 years. That is, qualification has to be obtained by 31st of August 2028 instead of 31st of August 2000 as originally directed. Needless to mention that it shall be the endeavor of the respective states and the competent authority to conduct the TET periodically and preferably twice every year, interspeed with an approximate speed period of 6 months between the success, so that teachers afford eligible teachers and we abundantly make it clear that no further prayer for extension of time would be granted. Okay, good. We dismiss your petition.
Lordship, as the Honorable Court has already observed that after my qualification, I can approach this Honorable Court. But there is another factor, Your Lordship. What about age limit? Now I'm already 30th, Your Lordship. Now I am in service for the last 14 years, Your Lordship.
So?
No, I'm not talking about appearing in TET exam regarding my service, because I'm already 38 now, Your Lordship.
So?
Then again, state respondent may say that I'm over age limit.
But for regularization, that is not the issue.
Lordship.
Regularization is not an issue for your age. Do they say out there by the state respondents, do they say that regularization as per 17/3/2015 is given to people who have even retired? So how does it happen?
Lordship.
Then, but your case is for getting equal scale to equal pay with that regular employee. You cannot get it, you don't have the qualification, and you don't have a BN, you don't have that. Without that, you cannot do anything.
Lordship, actually, my specific prayer was not with, no doubt, there are other prayers, but I have forgone all those prayers. Only I was stressing on the prayer that what Sri Tompang Aunok was getting. That same salary I should get as a substitute teacher. That was my
impossible in view of the Bihar judgment. Impossible. You can't give it to you. Anyways, heard Mr. Suryan. Withdraw, dismiss.
Lordship, if this honorable court can, after detecting the order, I may be allowed to, after having qualification, to again approach this honorable court.
That is there.
Lordship.
You can approach this court for seeking the same reliefs in the circumstance you have the qualification.
So, Lordship, if that can be reflected in the order, Lordship.
Yes, that I will deal with. But I would not allow you, you approach this court, I can give you. But I can't allow you, direct them to consider your case unless you have the qualification. Once you have the qualification, only I can. But you are going to appear, you will pass out BA, you will pass out all these things. That is not a question which this court can today foresee, taking into account you yourself say you are 38 years old. You have been granted an extension now by the Supreme Court in this judgment, which I said, to get the
Lordship.
within 31/8/2028. So you can very well get it. You still have another 2 years left. And there is also a direction that every 6 months there would be a TET examination. So in pursuance to that, you pursue.
Lordship, in that matter, I may be allowed to withdraw with the liberty to approach again this honorable court.
After having
Thank you.
qualification. After
Lordship,
the
Lordship.
Heard Mr. P. Suryan, the learning counsel, appearing on behalf of the petitioner. Mr. K. Angami appears on behalf of the state respondents. Gusto. The petitioner herein, who is working as a substitute teacher in the government middle school at Chakchor village, Kifri, has approached this court seeking a direction upon the respondents to pay the petitioner the regular scale of pay, which is and which a graduate teacher is entitled to, on the ground that the petitioner have rendered, as on the date of filing of the petition, 12 years of service without any break. This court duly takes note of that for becoming a graduate teacher, the requirement is stipulated in the Nagaland School Education Service Rules 2017, and more particularly at Rule 7B Roman 2. First, the said qualification being relevant is reproduced herein under page 20 of the affidavit. Yellow mark reproduced herein under. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner at present has the qualification which is required in terms with clause Rule 7B Roman 2, which has been quoted herein above. The learned counsel most fairly submitted that the petitioner is a graduate but do not possess the B.Ed or the B.A.E.Ed or the B.S.E.E.Ed from the National Council of Teachers Education recognized institution, or as well as the teacher eligibility or had qualified in the teacher eligibility test conducted by the SCERT. The learned counsel, however, submits that in view of the recent judgment of the Supreme Court in the case of State of UP versus Anjuman Ishaq E. Talim Trust and others, reported in 2026 INSC 597, the petitioner still has time to qualify in the TET examination up to 31/8/2028. The learned counsel further submitted that the petitioner, in view of the objections so taken in the affidavit in opposition, would not like to further pursue the present writ petition. But the petitioner, but the withdrawal of the instant petition should not prejudice the petitioner to again approach this court. If upon the petitioner obtaining the necessary qualification as is required for a graduate teacher. Considering the submission, this court closes the instant writ petition on withdrawal. This court, however, observes that the withdrawal of the instant writ petition shall neither prejudice nor preclude the petitioner to again approach this court, subject to the petitioner obtaining the qualification as is mandated under Rule 7B Roman 2, if so advised. Okay?
Lordship. Obliged, Lordship.
For admission, item number 3.
Yes. What is your matter? What happened?
Which was listed on Monday by law. For my law.
Oh, so it has again come back. So now you are serious. Huh? That's the lesson. Heard Mr. Santiago, the learned counsel. Where is that 5/3/2018? Why have you mentioned it wrongly that you have enclosed that?
Yes, my lord. Instead of the office memorandum, annexer 8 has been re-annexed again, my lord.
Huh? Annexer?
8 and 9 is same, lordship.
What is that? 8 is what?
It is an adverted mistake.
Land Revenue Department.
Yes,
This has nothing to do.
yes.
9 has nothing to do.
8 and 9 is same. 9
What-
actually.
what are
annexed
these?
that Office memorandum 2018.
These are not office memorandums.
April. The 3-year lordship.
Now here he has stated this. These are the documents,
Yes, lord.
and more particularly the document of that subdivisional officer. Now this subdivisional officer has to be vetted by the Deputy Commissioner Mokoksum.
No.
So we direct the Deputy Commissioner Mokoksum on the basis of the report to adjudicate, to find out as to whether there was an oral agreement in terms with clause 3B. And thereupon, if it is so, the petitioner would be considered in accordance with the office memorandum, isn't it? Where is that? What is this 16th April?
This is you. Then lordship, this memorandum, my lord.
This is another one. There was another 5/3/18. What is that? Another one. Anyways. Heard Mr. Santiago, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1 to 6. The present petition has been filed by the petitioner, being aggrieved by the non-consideration of the respondents to appoint the petitioner on land ownership basis against the vacancy caused by the retirement of Srimati Wati Sangla, who was a chowkidar in the PWD RNB Changtongya Division Mokokchung. It is the case of the petitioner that the petitioner's father, Sri Purnu Lu, along with others, donated the plot of land on which Changtongya office and the central store of the PWD (RNB) subdivision Changtongya was established. The land was jointly and severely donated to the department on the verbal assurance given by the department that appointment to grade 4 post shall be given to the landowners as and when vacancy arose. This aspect is also verified by the Changtongya Village Council in the certificate issued by the chairman Changtongya Village Council, which has been enclosed as Annexure 2 to the petition. In the Changtongya office complex and the central store, a vacancy arose of a grade 4 post, which was caused due to the retirement of Srimati Wati Sangla, who was a chowkidar. The Changtongya Village Council recommended the name of the petitioner The petitioner also submitted an application against the aforesaid vacancy on land ownership basis, being the daughter of the original landowner / donor. It is the further case of the petitioner that in the meantime, there was verification being conducted. The office of the customary court, verification conducted. However, in spite of that, as the petitioner's case was not being considered, the petitioner had approached this court by filing the present petition. The record reveals that this court, by an order dated 12/6/2025, issued notice. No affidavit in opposition has been filed by the respondents till date. However, when the matter has been taken up, Mr. So-and-so, who appears on behalf of the state respondents, submits that a verification was conducted, and in the said verification, and while conducting the verification, the head DB of the Office of the Customary Court, Changtongya, Nagaland, had submitted a report on 5th of July 2025 to the effect that a joint verification was conducted at PWD RNB Division Changtongya, attended by the Council of Members, landowners, and department officials to verify the land ownership status of the petition. The verification confirmed that the petitioner was indeed a genuine land owner of the division. It was also confirmed that neither the petitioner nor any family members have availed or received any undue benefit or privilege by virtue of becoming a landowner. In that regard, the Learned Council had submitted the said verification report of the Office of the Customary Court, Changtongia, Nagaland, dated 5th of July 2025 before this court, which is kept on record and marked with the letter X. The Learned Council, appearing on behalf of the respondents, further submitted that based upon the said report dated 5/7/2025, which has been kept on record and marked with the letter X, the subdivisional officers civil Tuli, Nagaland, have further submitted a report to the Deputy Commissioner Mokokchung, which is Mokokchung, to the effect, thereby forwarding the verification report of the DB and Village Council Changtongia on 24th of July 2025, which is kept on record and marked with the letter Y. First, from the above, it is seen that there has been certain verification being conducted at a particular level, whereby reports have been submitted to the effect that the petitioners belong to the family of landowners who have donated land and have not received any benefit thereafter. This court now finds it relevant to take note of the office memorandum dated 16/4/2018, and more particularly clauses 3A and 3B, which being relevant. Where is 3B?
Next week, my lord.
A 3A, na? There is a difference out there. Na? There is another one. Isn't it another one is there 5/3/2018?
Oh, sure. Yes. Not one that I know of, my lord.
5/3/2018? There's nothing.
No, my lord. But now this is 16 March 2018.
Sure, sure. Show me that. No. But I remember there is a 3B and 3C also. How it is to be proceeded with.
That we called up the subdivision of the inquiries at the bar, my lord.
You have got it from this, huh?
Yes, my lord.
This is not the document. Do you have a copy of it? Anybody? Doesn't seem to be proper. This is another. finds it relevant to take note of clause 3A, because why they have put 3A without, there was no necessity of putting 3A if it is 3. See this document. The document which he plays, why a person will put 3A? 3A would be put if there is a 3B. Otherwise, they would have put 3. Something. I think there's a it's 5,8,000. Yes, it is 5/3/2018. I'm right. Many of the questions it has been mentioned. All the cases they have referred to 5/3/2018. Yes, 5/3/2018. Therefore, you have 3A. What is 3B? If there is any claim for providing employment as a result of oral agreement, 3A in cases coming under 26/7/2000 and subsequent to setting up of administrative and block area. This is the document. And this has been issued by one Pankaj Kumar, IS Chief Secretary. And this is by some Temzem Toy.
Yes, my lord. Lordship, served after Pankaj Kumar.
Whatever may be. But there seems to be, because I say there's 3C also. It is also clarified that it is not the policy of the government to provide. That is 3C. And this has been reported in the judgment, no, I tell you. Yeah. You are, therefore I said it is 5/3. I remember better. Can't be 16/4. A judgment to thuna 5/3 kana se. The recent judgment on 5/3/2026 passed by Justice Karda Kete on this aspect. He also takes note of 5/3/2018. A judgment to Asegam. You just use it, huh? WPC number 66/2025. Oh, there you will find that. Dated 3/5/2026. From there you will put this. Not this one. This way, you got it somewhere. It seems to be incomplete because of the fact that there is no 3B. No 3C. Why on earth there will be a notification saying 3A when you don't have 3B and 3C? Yes, Mr. Satyendra, does it make any sense?
Yes, Lordship, this is B.
No, you see this B. What is 3A is different. Can you see this document? See this. See this document.
Yes, my lord.
And you see 3A down below, 3A, then you have 3B. 3A pertains to written agreement, 3B pertains to oral agreement, 3C says on perpetuity.
This also.
Something is missing in between here, in this also.
This works you. And it seems the office memorandum that I have placed, my lord, it was issued after this 5th March in the same year.
Understood. But that it doesn't say that. How does you take note of
Yes,
it?
my
Go
lord.
as per 5.3.
My lord.
Give it to me. This court finds it very relevant to take note of. The office notification dated 5/3/2018 issued by the Government of Nagaland. Government of Nagaland Land Revenue Department. Wherein it categorically mentions as to what steps are required to be taken in the circumstance a claim is made of an oral agreement, claim of appointment for appointment on land ownership basis can be made, can be dealt with, which is based upon oral agreement. Clause 3A, 3B, and 3C being relevant of the office memorandum dated so and so 5/3/2000 of the notification dated 5/3/2018 being relevant is reproduced here in under. From a perusal of the said notification, it is clear that the authority who is required to make the final recommendation on the basis of land ownership in a case coming within the ambit of an oral agreement is the Deputy Commissioner of the district. It is seen that as far back as on in the year 2020, or as far back as on 24/7/2025, the subdivisional officers civil have already submitted the verification report. However, a duty which is cast upon the respondent number 6 by the notification dated 5/3/2018 have not been carried out. It is also the opinion of this court that without carrying out the said exercise by the respondent number 6, the petitioner cannot be considered to be appointed on land ownership basis. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. The respondent number 6 is directed, the respondent number 6 and more particularly, that is the Deputy Commissioner Mokukshon is directed to consider as to whether the petitioner is entitled for her claim on appointment on land ownership basis on the basis of the reports being submitted by the subdivisional officer civil Tuli, as well as the verification being carried out by the office of the customary court Changpongya, Nagaland. The said exercise would be completed within 30 days from the date a certified copy of this order is served upon the respondent number 6. Next. It is further observed that based upon the recommendations so made by the respondent number 6, the other respondents in the present proceeding shall consider the case of the petitioner for appointment on land ownership basis in terms with the office memorandum notification dated 5/3/2018 or any subsequent notification which have been issued, notification office memorandum issued in that regard by the state of Nagaland. The said exercise be completed by the other respondents on the basis of the recommendation preferably within a period of 3 months from the date of recommendations received from the respondent number 6, that is the Deputy Commissioner, Mokuku.
Deep Lopez. This is the eighth case that my lord has disposed in your present visit.
Huh?
This is my eighth case that my lord has disposed in your present visit.
Oh,
Earlier, when my lord disposed maybe 3 of my cases.
it means you are taking the chunk of the litigations of the other councils.
If my lord keeps coming, I may not need to appear before this court.
Why?
There will be no cases left.
Okay, from now on, what is you? Why on earth did you give that undertaking and got this matter listed? I said it, we adjourn Sinodite till there's an interest being shown by the council to do the matter.
It's better to get the matters disposed as early as possible.
You see, now the person concerned, you never know that things may change. Tomorrow that a post may be a given appointment to anybody else,
My lord.
which may be difficult. So with this, now within 1 month and then 3 months, if they do it, that person will get a job.
My lord, I'm deeply obliged.
For admission, item number 4.
Yes, madam, what is this?
Lordship, I just received affidavit filed by the state government in the morning, Lordship. So,
You want to file a reply?
Lordship, yes, allow me to seek some instruction, Lordship.
What is the matter about?
The matter is about the construction of the water reservoir, Lordship, which
Yeah.
has been, as per the agreement entered with the government of Nagaland, prison department, Lordship. Now, what has happened is there's an agreement executed to that effect on 8 November 2012, Lordship. And that the construction, water reservoir was constructed without any, the petitioner here has made out-of-pocket expenses, Lordship.
You made it.
Yes, Lordship, and I've invested more than 20 lakhs in the year 2012. Now, after using my service for so many years, Lordship, suddenly the allotment, the land that was allotted to me was cancelled, Lordship, which is impugned in this petition.
What land has been cancelled?
It's a
Termination
government
of
land.
temporary allotment site
It's a government land, Lordship.
for allotment of the one government compensated land to the for the district poorly allotted to so area with immediate effect. Why it is terminated? And what do you do out there?
Lordship, on a very flimsy ground, I did not breach any terms of the agreement, Lordship.
In the 1972, between so and so and so and so. Human structure, if any particular value of a set of human remains and no transfer to government and voluntary transfer the same. The government is native. Title the government should be and the nation itself and even people in country and to be should be trying to be encouraging the we have given all the person So on the basis of that, you have, due to scarcity of water at district so and so, the first party has agreed with the second party to allot plot of land to the second to construct a temporary water reservoir tank
Lordship.
and related purpose on the land occupied by so and so to distribute water to him, that the first party shall pay rupees First party per month to the second party for supply of water. Both parties have agreed to enhance the rate up to 3 to 5 years. This is the agreement. Then
Lordship, yes.
temporary allotment of site has been given on clear. Then you constructed.
I constructed, Lordship. Out-of-pocket expenses was made. In fact, Lordship, even to maintain the water reservoir, I'm employing 3%, which I have not taken any money from the government to maintain, Lordship. 3%
Of the temporary.
plus I'm paying about 7,000 monthly as electricity bill, Lordship. Then comes
You are
maintenance
getting how
bill.
much? You are getting how much? 5,000.
So 5,000 from the prison department, Lordship. I was getting. Then I had to, because initially when the water resources, the reservoir started operating, Lordship, the water sources became very good, Lordship. In fact, it's a blessing, Lordship. Now Mokchung town is suffering. I mean, there's a scarcity of water, which is already I've enclosed even the statement of the jail superintendent.
Now are they anybody using the water?
Now what has happened? Interestingly, they have dug a borewell, Lordship.
Oh,
And now they say my service is not required. Now what has happened? Lord? Interestingly, they want to take over the reservoir which I have maintained and invested for years, Lordship.
so there's
Without-
a stay. You have got it. You have got a stay.
Yes, I got a stay, Lordship.
Okay. But are you supplying the water? No.
I am supplying, Lordship. I'm ready to supply
No,
water.
you are ready to supply is different from are you supplying?
I was supplying, Lordship.
You
to the
was,
police department.
yeah.
Now they don't want it anymore.
So you are into the
That's
past
the
tense.
case.
You
That
are
is
into the
case.
past tense now.
Yes, Lordship. That is
So you are not supplying. So therefore there is a stay. And they have filed an affidavit. And but madam, there is a big problem with you is problem of your case is allotment was granted to you by whom?
Yes, Lordship. I'll take it there, Lordship.
By the deputy commissioner.
Yes, Lordship.
Is it inside the jail?
It is, Lordship, in fact, Lordship, what is my family has done, the government has acquired the land for my property, family, Lordship. Now, I'm not claiming any ownership with that land. But the purpose was only given for the purpose of construction of prison, Lordship. Now, there are many other residents, private individuals who have constructed, Lordship, permanent structures. They are residing in Lordship in the government, the same plot. There's a gas reservoir has also been constructed. And there are other people operating, Lordship, workshops. And other activities are going on in the government land. Why they are not having problem with any of those? Why are they particularly attacking me? Is a question, Lordship. I mean, Your Lordship.
So you have filed an affidavit.
Yes, Your Lordship.
That is not on record. We do one thing, let the affidavit come on record and you must have stated the reasons.
Yes, Your Lordship.
And she will like to file a reply as well.
Lordship, I want to seek instruction if needed. I would text them as per the instruction. is
But
seek,
when
Lordship.
they are refuting it, don't you think that there is a necessity for you to reply?
Lordship, yes, I just briefly went through it. Some allegation was also made by certain.
So now you are granted a settlement. You are granted a settlement holder. You look into, you see this page 39 of your document. You see the structure is yours.
Lordship,
Structure is yours.
yes,
The land has been allotted to you
Lordship, by the government.
under what provision?
Temporary provision, Lordship.
No, madam. You see rule 16 of the settlement rules
Lordship,
of the Assam land, under the Assam Land and Revenue Regulation. Then once you are done there, they cannot apply rule 18. They have to file a suit.
Lordship,
Take that ground in your lip, please.
Lordship.
Not on this. You don't come under, don't apply under section 70 of the Contract Act on the question of quantum merit. Quantum merit is a different thing. You may have to go to the civil court for that. But you see, this document at page 39 is a document which comes under Rule 16 of the settlement rules framed under the Assam Land and Revenue Regulation, where the Deputy Commissioner allows you temporarily to reside pending settlement to be done. If that is so, they cannot exercise Rule 18. Rule 18 is a summary eviction. They cannot do so. If they cannot go for that summary eviction, they have to file a suit. And suits, you know how long it takes. Okay. Ms. Amy, the counsel appearing on behalf of the state respondent submits that they have filed an affidavit in opposition. Ms. Nito Khoza, the learned counsel appearing on behalf of the petitioner, submits that she would like to file a reply. Considering the above, the matter stands adjourned to be listed again on 21st of July 2026. In the meantime, the reply be filed on behalf of the petitioner. Interim order passed earlier shall continue till the next date of listing.
For admission, item number 6.
Yes.
Yes, madam. My lord, I have received a copy of the affidavit of filed by the state respondent only this morning, my lord.
What do
So
they
only around 2 weeks time to file.
Why you are filing reply? You have not, they have not denied the amount.
Yes, sir.
Yeah.
My lord, I am on behalf of person number 1. And I filed my affidavit on.
Is the finance department a party?
No, no, my lord.
Why?
My lord, the reason is not stated in paragraph 4, my lord. The lordship can see my affidavit. Why the bill has not been released. My lord, in the paragraph 4, it clearly says that my lord, the supply order dated 9/7/2048 was awarded without the knowledge of the department. And in this regard, there was neither a proposal or administrative approval from the company. However, on 2016, along with the bill amounting to rupees 13 lakhs 61,115 received from the registry members. And said that letter was forwarded to the finance department, my lord, because your lordship may kindly appreciate that without the additional fund coming from the finance department, the department cannot release the fund. And my lord, when the letter was forwarded to the finance department, it was turned down.
So therefore, when you are mentioning he's asking for 13,61,000,
Yes.
you are saying that you are moving the finance department.
Yes.
Meaning thereby is the administrative department acknowledging that you have to pay him. My question is that.
Yes, already forwarded to the finance department, but it was
Not understanding. You see, there are two things. One is payment and the other is whether he has supplied. You are saying that there was no administrative approval.
yes.
If there was no administrative approval, could that order have been given? Couldn't it be a supply being made? Have you made the verification whether he had supplied or not?
No, my lord.
Then without that, why are you admitting this, that you are moving the finance department? First, you have to find out, because it is the finance would not come into the picture till the administrative department finds out that as to whether the petitioner has supplied in the year 2014 this amount as per 13,16,000. Normally, what is he required to do? He has to file a suit and prove it. It is only in a case where you admit to the liability, this court says that it would be unfair for him, on the part of the state, not to make the payment. And it is under such circumstances we exercise wholly to be a violation of Article 14 and accordingly direct payment. This is how it is being done. So my question is therefore, did you verify? Why are you moving the finance department without verification whether he is entitled or not? Unless you want to say that you admit it. If you admit it, it is a bit different question. You are appearing for?
My lord, in regard to verification, whether the petitioner has supplied the item.
Forget about that. You have not taken up that plea.
Yes, ma'am.
Then
And the letter is, my lord.
you are the Gauhati High Court.
Yes, ma'am.
What is that? Did he supply? He supplied to whom? You supplied to the Gauhati High Court.
Yes, ma'am.
Show me. And
Department. It's dated 5th March 2026.
it's okay. Now, so therefore, if the supply, it doesn't require your administrative approval for that. So the order must have been placed by them, Gauhati High Court,
Yes.
to him. He supplied it to the Gauhati High Court. And Gauhati High Court has not been able to pay. And therefore, he has filed the writ petition. Now the question is it your stand? Have you made the verification whether he supplied or not? And why you are moving the finance without they saying anything?
My lord, based on the letter received from the registry.
Understood very well. But have the registry made the verification? Where is your statement? Where is your affidavit?
My lord, we have not received any instructions to file an affidavit from the registry. This is the only thing we received from the registry.
No. Has this court not issued the notice? We made it very clear. The petitioner has filed a petition seeking a direction upon to which the petitioner claims to be an account of supply. The respondents herein are directed to bring on record their stand by filing affidavits on or before 4/5/2026. So you have failed to do so. We asked
The order to the registry, however, we have.
we
not
impose
received anything from the
impose a cost of 10,000 on the High Court for not filing the affidavit. This is in violation to the court's order.
Can we be allowed to?
No,
Tax maybe.
yeah, this matter has come up many times. They have no business out there. There are directions should have been issued to you. You are the person who have consumed the materials which he has supplied, and you have not filed the affidavit. I'm sorry to say, my learned ordinate bench has imposed upon you to file the affidavit. Your affidavit will come later on. Subject to they have verified. Why haven't you filed? We impose a cost of 10,000 on the Gauhati High Court to be paid to the legal service. Huh?
I may be allowed some time then too, because we have written to the registry, however, we did not receive any Paramount's communication from the registry.
The registry knows about that particular document, as I could see, they have written it to the government. But whether the registry has recorded, had verified whether he has supplied or not, and why he is approaching the court so late. The supply was made in the year 2014. He filed the first, submits a legal notice in 2016. Then he again slips for another 2 years and comes in 2018. And after that, again, he goes to a deeper slumber and comes in 2026, it will be now next to impossible for you to verify. Have you seen my order which I have passed out there where I say the maintainability of the writ petition is kept open insofar as delay in latches are concerned? So why haven't you filed the affidavit? Cost.
Maybe given one last opportunity.
Last opportunity. You don't file, this affidavit is in your favor. In fact, they should withdraw this affidavit. You say that you want to file an additional affidavit because the verification, without that verification, it becomes very difficult. Make that submission.
Okay, my lord, I have not received a copy of the state affidavit also, so I have
Not
received-
required. State says that you will pay him. They are moving to the finance department.
So, Lordship, if one opportunity will be able to.
Yes. The record reveals that this court, by an order dated 16/3/2026, issued notice and specifically directed the respondents in the petition to bring on record their stand by filing the affidavits on or before 4th of May 2026. It is seen that the respondent number 1 and 2 have filed the affidavit in opposition. However, it is disheartening to note that the respondent number 3, to whom the supply was made, to whom the petitioner claims to have made the supply, have not cared to file the affidavit in opposition. On account of the conduct of the respondent number 3, this court is not in a position to proceed with the disposal of the writ petition. Considering the submission made by so and so, the learned counsel appearing on behalf of the respondent number 3, this court grants a final opportunity to the respondent number 3 to bring on record the stand to file the affidavit. Mr. Informed the learned counsel appearing on behalf of the petitioner, respondent numbers 1 and 2, submits that the said affidavit so filed by the respondent number 1 and 2 be taken as a preliminary affidavit, subject to further verification on the basis of the affidavit to be filed by the respondent number 3. Taking into account the above, a further liberty is given to the respondent number 1 and 2 to file an additional affidavit after the affidavit is being filed by the respondent number 3. List this matter on 22nd of June 2026. The respondent number 3 shall file the affidavit on or before 19th of June 2026.
For orders, item numbers 19 and 20.
Yes, madam.
Yes, my lords. So, my lords, this issue, my lords, arises before this honorable court, my lords, on account of the judgment of the Honorable Division Bench of 22nd April 26, whereby, my lords, differing views were held by my Lord Justice Buddhi Habung, my lords, and my Lord Justice Phukan, my lords. So, therefore, my lords, a reference to this honorable court, my lords. Whereby, so, my lords, we have, for your lordship's convenience, my lords, we have put out some questions for reference, which my colleague, my lords, would hand over to this honorable court, my lords. So all these arise, my lords, from the judgment in question, my lords, and the views held, my lords, by the respective judges, my lords.
You are, who are you?
My lords, I'm the appellant, my lords, People for Animals, my lords.
You're the People for Animal and an Animal Welfare Organization.
Yes, my lords, I'm an organization, my lords.
What is your basis out here to file the writ petition?
My lords, my basic, I'm sorry, my lords, I didn't hear your lordship.
What is your basis for filing the writ petition?
My lords, I'm an organization which works for the benefit, my lords, of human society, my lords, and for the protection also of animals, my lords. And I have, my lords, at several occasions taken up these issues on public platforms, my lords, as well as in court litigations, my lords.
Okay, now, my scope of my adjudication would be to see as to whether either of, I have to follow either of one of the judgments passed by the learned judges.
Yes, my lords.
Because the
Actually, your lordship might be guided by section 98 CPC, my lords.
So therefore,
Yes.
go as per 98 CPC, don't you think that the scope of the proceedings is limited? Because if it is section 98 CPC, then only I can look into the question of law. Not
Yes,
of
my lords.
fact. But taking into account that this was an appeal filed in exercise of the powers of the latest Patent Act.
Yes,
Because
please.
in Gauhati High Court, the appeal is under clause 14 of the latest Patent Act, which is that of the Calcutta High Court.
Yes, please.
So there, I can go into both the facts as well as the law.
Yes, please.
But here I'll be under 98.
Yes, please. Your lordship is right, my lords. Section 98, we had also looked up, my lords, and it seems your lordship will be guided by section 98. And the position is, my lords, that what was impugned, my lords, ultimately was the notification issued, my lords, banning the prohibition, banning, my lords, the killing of dogs, my lords, for commercial import, export, and commercial dining in terms of regulation 2.5.1 of FSS regulations. That is a subject matter, my lords, in hand.
So we are
And
to look into
yes.
only on the question of law.
Yes, my lords. So that's why, my lords, we had framed these three questions, my lords, which take into account the views of the respective judges.
You want to support the judgment of Justice Habung?
My lords, I want to support the judgment of Justice Phukan, my lords.
Justice Phukan has said that, what did he say?
My lords, he said that the prohibition, my lords, and the banning is in accordance with law, my lords. It upholds, my lords, the circular, my lords. It upholds the notification issued pursuant thereto. So just to give your lordships, my lords, a brief overview, my lords. The entire matter, my lords, arises out of the following, my lords. If your lordship will take the impugned judgment,
No.
I will show 3 documents to your lordships which are in issue.
Which are the documents?
Yes, my lords. They are reproduced in the judgment, so I thought it would be convenient. So page 72, my lords,
Of which judgment?
of the division bench judgment, my lords.
Of
22nd April, my lords, 26.
both the judgments are of the same date?
Yes, my lords. They are part of the same, my lords. Whereas from page 5 to 31 is Justice Habung's, my lords, judgment, and from page 31 to 87 is Justice Phukan's, my lords.
Where are you finding out that? Because in the judgment which I am having,
Yes, my lords.
5 to 35, 4 is of Justice Habung, and 1 to 61 is of Justice Phukan.
I see, my lords. I obviously have some other version, my lords, than from the Gauhati High Court, my lords, from the bench. So I'm having a slight variation, it seems.
Which judgment are you referring to?
My lords, I'll have to check with my colleagues for 1 second, my lords, which one they have got it from. Maybe it's a reported version, my lords. Could my colleague please just tell which judgment I have from which source?
You will have the one reported by the High Court, ma'am.
Reported by the High Court.
Yes. The one that was forwarded to us by the local council should be the same.
Yes. So, my lords, I have the reported version, it seems, because I have the citation on top, Gauhati NL 234 DB.
Okay, you are referring to whose judgment?
Because I'm referring to 22nd April 26 judgment.
There are 2 judges who have given different judgments.
Yes, yes. My lords, I actually have them in the same sequence, my lords.
My lords, it's a
That's
common judgment.
Common judgment will is what I have, my lords. And I have it from page 5 to 31 of Justice Habung and 31 to 87 of Justice Phukan, my lords.
Then let us, because I think Justice Habung allowed the appeal, dismissed the appeal. And then all the issues are dismissed. So it dismissed the appeals. So the one which is dismissed the appeals.
Yes, my lords.
Yes, which paragraph are you referring to?
Because I was referring to page 72, which possibly is a part of my Lord Justice Phukan's judgment, but irrespective, it's page 72.
Do you have a paragraph?
My Lord, this is paragraph 75.
I think you must be taking into account this SCC online or something, because here Justice Phukan's judgment is of 26 paragraphs, whereas Justice Habung's judgment is of 56 paragraphs.
I also have the CTC copy of the judgment. And Justice Budi Habung's page judgment runs from page 5 to 31.
You have a copy?
Yes.
Show me.
Maybe your Lordship could use the same copy, my Lords, it might. Now, my Lords, with variety of publications available, sometimes it proves to be a nuisance because we are referring to different.
Now, okay, this is the main judgment, so they have made it different.
Yes.
Paragraph you are referring to, page?
Yes, my Lords, page 72, which are the pages are at the bottom, my Lords.
Yes, yes, got it.
Yes, my Lords. And this is part of paragraph 75. So, my Lords, the origination is this, my Lords. This follows at page 72 at the bottom. Your Lordship will find file number so and so, Food Safety and Standards Authority of India, Ministry of Health and Family Welfare. So this, my lords, is a circular dated 6th August 2014, which reads as under, my lords, subject slaughtering of animals not permissible under the FSS Act and regulations. Your kind attention is invited towards Regulation 25 of the SS Food Product Standards and Food Additives Regulations 2011, whereby definitions of animal carcass and meat are given. As per subregulation 2.51a, animal means an animal belonging to any of the species specified below, ovines, caprines, suolines, bovines, and includes poultry and fish. So I'll just point out, my lords, this does not include dogs, my lords, as such, my lords. The slaughtering of animals of any other species other than the one listed below is not permissible under the FSS Act and regulations. In view of the above, you are requested to kindly strengthen the vigil and ensure the compliance of the provisions of FSS Act 2006. Yours sincerely, Bimal Kumar Dubey, Director Enforcement, which copy is endorsed to all the Food Safety Commissioners. So this, my lords, is the origination of the circular issued by the Government of India, the Ministry of Health and Family Welfare, and, my lords, addressed to all the Food Safety Commissioners, intimating, my lords, that slaughtering of animals other than the species above is not permissible under the FSS Act and the regulations. This is, my lords, followed by a cabinet decision on page 74, my lords.
Yes.
This cabinet decision appears, my lords, in the middle of the page. Government of Nagaland, Cabinet Secretariat, Cabinet Cell, number so and so, the 4th of July 2020. Minutes of the Cabinet meeting held on 3rd July 2020. The undersigned is directed to forward herewith an extract to the minutes of the Cabinet meeting held on 3rd July 2020 for kind information and necessary action. Agenda number 8, ban on import and sale of dog meat in the state. The Cabinet deliberated on instances coming to light of import and commercial sale of dogs for their meat in the state. The Cabinet observed that dog meat falls within the family of canine, which is excluded from the provision of Regulation 2.5 D subclause A of SSAI Regulations 2011, which regulates and defines a meat sale and consumption, and thus the existing law does not permit the slaughter, sale, and consumption of dog meat in the country. The Cabinet, after due deliberations, decided for issuance of orders banning the following: commercial import and trading of dogs and dog markets, commercial sale of dog meat in markets and dine-in restaurants. Necessary orders will be issued by the Chief Secretary in this regard, backed by relevant sections of law, and the same will be enforced by district administration, police, municipal administration, and the veterinary and animal husbandry, severally as well as jointly. Action taken on the matter may be intimated to the Cabinet Cell, and this, my lords, is signed by the Additional Secretary to the Government of Nagaland, and copy endorsed, my lords, to the Deputy Secretary to the Government of Nagaland, Office of the Chief Secretary, Nagaland, Kohima. Thereafter, my lords, this is followed by the next, my lords, page, same page, my lords, at the bottom, by a notification by the Government of Nagaland, which reads as under, my lords, Government of Nagaland, Office of the Chief Secretary, Nagaland, Kohima, dated Kohima, the 4th of July 2020. Whereas the central ban on import and sale of dog meat in the state, whereas the central government, Ministry of Health and Family Welfare, has enacted the Food Safety and Standards Act 2006 and the Food Safety and Standards Food Products so and so Regulations 2011, regulation for short, to regulate the safety of food articles safe for human consumption. And whereas in Regulation 2.51A of the FSSAI Regulation 2011, meat and meat products, and as per sub-regulation 2.5.1 bracket A of the regulation 2011, animal means an animal belonging to any of the species specified below, which is ovines, caprines, suolines, bovines, and includes poultry and fish. And whereas the slaughtering of any other species other than the ones listed in sub-regulation 2.5.1 subclause A of the regulation is not permissible under the FSS Act and regulations. And whereas for strict compliance of the FSS Act and regulation, And in order to regulate the safety of food articles safe for human consumption, it is necessary to ban slaughter and sale of dog meat in the state of Nagaland. Now, therefore, in consonance with the provisions of the FSS Act and regulation, the following are banned with immediate effect. Commercial import and trading of dogs and dog
But
markets.
exercise
Yes.
and saying to be a violation is not under the FFS Act.
Yes.
Quoted the provisions of the IPC.
Yes, Manoj. That is in paragraph 5, Manoj.
So this would
It
be
is-
a communication within the meaning of Article 162.
Yes, Manoj.
This is a power being exercised on that basis. Because
Yes, Manoj.
either reference to the FSS Act as well as the regulations which are mentioned out there that these are which is permissible as food. And then they, on the basis of the cabinet's decision, they say
Yes.
if anybody does anything, it will be punishable under the IPC.
Yes, Manoj. It is actually punishable under the IPC as it stands, and now Manoj, under section 325 of the BNS, the new act, Manoj, and also under the section 11 of Prevention of Cruelty to Animals Act, Manoj. So both Manoj provisions exist in the statute, and they are punishable as we stand today, Manoj. Of course, the IPC is superseded by the BNS, but aside from that, the provision remains as it is. And this is so mentioned in paragraph 5 of this notification, Manoj. And then this enforcement, Manoj, is sought of this, Manoj, issued by the Chief Secretary pursuant to the Cabinet decision, Manoj. And in addition, Manoj, pursuant to the circular of the Government of India, in pursuance, Manoj, I would also put it Article 256 of the Constitution and Section 86 of the FSSAI Act, Manoj, which so empowers the process, Manoj. So, Manoj, this is the essence of the challenge was to these notification as well as to the circular, but the circular, Manoj, was upheld, as in it was not set aside. By the single judge, Manoj, the notification was set aside, Manoj, and that was a subject matter of challenge before the learned division bench, Manoj. And that, Manoj, subsequently, Manoj, came up to the present situation whereby differing views having been held by the two honorable judges, Manoj, the matter comes up for consideration here. The subject matter is these three documents, Manoj. And I'll also mention, Manoj, while we are at it, Manoj, that the circular itself has been upheld in a judgment of the division bench, Manoj, of the concerned court, Manoj, of the division bench in Hivzur. This came up for consideration, Milords, and the circular itself has been upheld even there, Milords, and the learned single judge has also not, Milords, set aside the circular, and no appeal has been filed against that position before the Honorable Court. The only view held, yes.
One thing, whether this FSS Act would come within the ambit of customs?
Milords, it doesn't.
It
doesn't.
Yes. Dog meat.
Yes.
Is considered to be a custom in Naga.
Yes.
Wouldn't that come under the chief of Article 371A of the Constitution?
Milords, firstly, the view on Article 371A, Milords, has, in fact, it has been held that that was not so urged before the learned single judge and therefore should not be applicable. In any case, Milords, it is a further finding. In fact, it has been so framed, Milords, as a question also. It doesn't fall within the purview of custom under Article 371A. We can support that also, Milords, and that is a view also taken by the learned judges, Milords, in the matter, Milords.
This one.
Because the protection, Milords, would be also to a limited extent. It is not unless and until, Milords, it is so held. And it is, Milords, ultimately it has been held that it is a serious public health risk, Milords, under Article 21.
Because 21, it is a health issue. We are not dealing with a PIL. We are dealing with an order being passed as to whether the challenge to the notification dated 4/7/2020, if that's not wrong.
Yes, Milords.
Right or wrong?
Yes.
How does Brother Abun take into consideration about Article 371A? Has either of the judges looked into that as well?
Yes, my lords. My Lord Justice Pokar, my lords, has held at page 83 in paragraph 77 onwards, my lords. And my Lord Justice Habong, my lords, has not taken a view on the subject.
Now, moving forward to deal with the argument of others, regarding applicability of the Constitution, I find that the affidavit filed by the state.
In the instant case, I find from the affidavit dated 25/2/25 filed by the state of Nagaland indicates that the state of Nagaland has not enacted the FSS Act by way of a resolution of the Nagaland Legislative Assembly, but it appears that the respondent number 1 to 3 herein had not raised the issue before the learned single judge by placing any material or necessary pleadings on record that are necessary to determine whether such a resolution is required. Over and above, no finding was also returned by the learned single judge on this issue. Now it has to be seen whether in fact a resolution is required to make applicable FSS Act in the state of Nagaland. Before a discussion is directed to the issue, let it be seen that the requirement of the Article 371A. This article provides that no act of parliament in respect of religious or social practices of the Nagas or Naga customary law and procedure shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. A bare perusal of the article reveals that only an act of parliament made in respect of social practices of Nagas shall require a resolution. Notably, FSS Act was enacted with the objective to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India for laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale and import to ensure availability of safe and wholesome food for human consumption and for matters connected therewith or incidental thereto. Thus, in order to substantiate applicability of Article 371A qua the FSS Act, it was incumbent upon the respondent numbers 1 to 3 herein to establish that the FSS Act was enacted with regard to the social practice of the Nagas. Indisputably, the subject matter of the FSS Act is public health and safety. It was neither directly nor substantially enacted on the religious or social practices of the Nagas. Therefore, I am of the opinion that for making the FSS Act applicable to the state of Nagaland, no resolution of the state legislature is required under Article 371A of the Constitution. Over and above, it appears that the state of Nagaland has been actively making efforts to implement various aspects of FSSA in the state. The decision of the State Cabinet in Agenda number 8 of meeting held on 3rd July 2020 is the testament to the same. In the said meeting, the Cabinet had discussed in respect of import.
That is
Yes.
very erroneous, taking into account that the law stipulates that it has to be accepted by the Legislative Assembly. Whether
Well,
the cabinet does whatever may be, that cannot be done unless the law says that it has to be done on the basis of a Legislative Assembly's resolution, isn't it? The law.
Whereas the law says that it should be by a resolution in the event that it falls within the parameters of Article 371A. Any law doesn't require a resolution. That's Article 371.
Any law doesn't require, it is only
Yes.
comes within the midship of 371A.
Yes. Correct.
Anything in the Constitution, no act of the Parliament, religious or social practice of Naga customary law and procedure, administration of so and so ownership shall apply to the unless the Legislative Assembly of a Nagaland by resolution so decides. So
yes.
It is done by the cabinet asking, doing out there would not do it unless that is being done. So that parameter which has been held by the Justice Pukon doesn't appear to be in good in consonance to the settled principles. Be that as it may, how does Justice Buding take into account 371A?
Well, before your lordship goes there, may I just go back for 1 minute on the same page, my lords? Para 77.3, my lord Justice Phukan holds, my lords, that the FSS Act is not enacted with regard to the social practice of the Nagas, and therefore, my lords, it doesn't require resolution. The cabinet part is the second part, my lords. So, my lords, if I just go back to 77.3, because FSS Act is with regard not to social practices, customary practices, or religious practices. It is in regard to health, wellness, and public health and safety. That is so held in para 77.3.
No, if
The,
that-
the,
no,
yes.
therefore the question is, if it is only health and safety, that is from the purpose of eating it. It
Yes,
is
Milord.
only for the purpose of consumption, but
Yes.
not to do with slaughtering. Slaughtering
Milord,
is in respect from consumption, because FSS Act is only for food safety.
Milord, what is slaughtered is eaten. What is eaten is slaughtered.
There are many
So-
things which are slaughtered,
Yes.
not eaten.
Milord, it may be so, but in the present process, Milord, your lordship is
Invite your-
conscious.
Madam, I
Yes.
think the Naga people should be inviting you to Hornbill.
Milord, what I'm saying is, I understand, Milord, we should always, Milord, visit whatever places we can, and I have had an opportunity in life to, Milord, visit most parts of the country. But be that as it may, Milord, what I was saying is that in this case, Milord, slaughtering of food or animals is only permissible where it is meant for food consumption, for human consumption. Therefore, Milord, the two are interlinked. Therefore, the whole process of slaughtering, my lords, under the laws as they stand in the country, including these slaughter rules, my lords, including the prevention of cruelty to animals, and the other rules, all envisage that food slaughtering can be only there for food, my lords.
But
And therefore, the licenses also which are granted under the various laws for slaughtering. Yes.
FSS Act
Yes.
stops slaughtering. No.
No, it doesn't. But the other acts too, my lords, and the rules
The
frame
very
thereunder too.
basis of the cabinet memorandum was that notification, which the notification that you can't slaughter FSS. It
My lords,
doesn't say you don't eat
yes.
it. It says
My
you
lord-
can't slaughter. If you see this particular document, which you have read it,
Yes, my lords.
of August 2014, the
Yes.
slaughtering of animals of any other kind, species other than the one above is not permissible under the FSS Act and regulations.
Yes, my lords.
So therefore, this is a particular thing for the purpose of slaughtering. Now, whether there is a bar on slaughtering by the Food FSS Act,
Because it is the bar is there under the slaughtering rules which are framed under the PC Act, my lords, as well as, my lords, the process of the law under the IPC and the BNS, my lords. Also, my lords, bans the same, my lords, and prohibits the same. So therefore, my lords, this isn't to be looked at in entirety. What your lordship is rightly saying is, my lords, that in
Madam,
normal situation,
we
yes,
can look into another angle. Forget about the
Yes.
FSS.
yes,
We can look into another angle because you see, if these are in violation of the relevant provisions of Section 11 and Section 11 of the Prevention of Cruelty Act,
yes, my lords.
or if it is in violation of a provision of the IPC, which is duly applicable, there's no quarrel with that proposition.
Yes, my lords.
Those are applicable, then in that case, the cabinet minutes should be in accordance with the Constitution, irrespective of, don't take up FSS also. It would be within the purview of the Constitution, it will be done under 161. It will be a cabinet memorandum. Now, a cabinet memorandum is just a memorandum unless it is given effect to by way of a notification or some instrument. Now, the instrument, the 4/8/2020, 2014 or 24, what is that document?
20, 20 minutes, 20.
4/8/2020 document.
Yes.
So 4/7/2020. So
Yes.
4/7/2020 document gives effect that if you slaughter or kill or eat a dog meat out there, that would be in violation of Section 428, 429 of the Indian Penal Code, read with Section 11 of the Prevention of Cruelty Act.
Milods, may I just, sorry to interject, Milods. What is banned, Milods, as per the notification, is commercial import and trading of dogs and dog markets. And what is banned is commercial sale of dog meat in markets and dine-in restaurants.
Okay.
Kindly see paragraph 4 of the notification, which emerges at page 77 of the judgment for convenience, Milods. So paragraph 4 is, this is the ban.
Okay. No, I'm on that. It's okay. No problem with that. I'm only
Yes.
You are referring to 325, huh? For the BNS.
Yes, my lords.
Killing or maiming, whoever commits mischief by killing, poisoning, maiming, or rendering useless an animal shall be punished with a. Let's see the IPC.
Yes, my lords, IPC is 428 and 429 of the IPC.
Prevention of Cruelty Act.
And then Prevention of Cruelty Act. The IPC, my lords, if an also has got that, my lords, is section 428.
325 is.
Because whoever commits mischief by killing, poisoning, maiming, or rendering useless any animal shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both.
Okay.
So, whereas killing of animals.
So it will include anything.
Anything, yes. So the only saving is, where food, is considered under the FSS Act.
And killing.
Yes.
This is only for killing.
Yes, my lords.
Poisoning, maiming, or rendering useless any animal or animals of the value of ₹10 or upwards shall be punished with imprisonment of either description which may
Up
be.
to 2 years, 2 years or fine or both.
Has the animal been described in the IPC?
Well, as animal is been defined in the BNS for sure. If I may just read out, and I'll go back to the IPC also, because I don't have it readily. But section 2, subclause 2 of BNS describes animal means any living creature other than a human being.
So if you kill a fish also, you can be put into prison for 2 years?
Well, I would take it that whatever is accepted by way of the FSS Act.
Because there is no exception in IPC or the BNS.
Your Lordship is right. On the face of it, there doesn't appear to be any.
So therefore, killing any animals.
Yes.
We bring 429. Now, you get something on 429, another thing is given. Whoever mischief by killing, poisoning, maiming, rendering useless any animal, any elephant, camel, horse, mule, buffalo, bull, cow, or ox, whatever may be of the value, or any other animal of a value of ₹50 or upward, shall be punished with an imprisonment for a year. So 429, do you have anything out here in the BNS taking into account that the value is just put at 50, where you don't get anything nowadays?
That's true, Manoj. The question is, the question is not the even ₹1, Manoj, fine on the imprisonment, Manoj, is what is sufficient to meet the parameters, Manoj, of criminal law, and the fact that it is an offense.
So there is no, because dog does not come within the ambit of 429 unless and until it is above the value of ₹50.
Well, 428 itself doesn't have that value.
No, 428 says about 10. Above 10.
And then 429 says about 50.
Because 429 specifies various type of animals.
Yes.
And apart from that, goes further that any other animal whose value is more than 50.
That's right.
So therefore,
yes.
So therefore, bringing 428 and 429 in paragraph number 5 of the notification seems to be a bit too vague, unless 428 and 429 categorically mentioned the aspect of, or more particularly 429 brought in dog.
This was not so considered, your lordship is right, but this was not so considered by any of the judges, my lords.
So therefore, this is it. Now let us see the Prevention of Cruelty Act.
Yes, my lords. If your lordship would take, my lords.
Mr. Samrat is assisting you, madam?
Yes, my lords. Yes, my lords.
Mr. Samrat, you may just check it out from the BANS as to whether do you have a parameteria provision to that of 429 in the BNS?
We'll do that, my lords.
Because now BNS is being an act of 2023, the value may have gone up from 50.
We'll just do that.
My lords, my colleague he's been working very hard on the matter, my lords, and hoping to get, my lords, the situation to your lordships. So, my lords, in the meantime, we look at PCA, my lords, 1960.
Animal is what?
Plus, animal is defined in section 2, subclause A.
Same like the BNS.
Yes, my lords.
Same definition.
Yes, any living creature other than a human being. And then, my lord,
here being
section-
another interesting 11G.
Yes, my lord.
Being the owner neglects or exercise or cause to be exercising reasonably any dog habitually chained or kept in those confinement below being yes, while willfully permits any animal of which he is the owner to go at the large. Here also it is the same thing. Here only they have extended. That is also 10. They have put it. Which may extend to 50. This is a punishable.
Your lordship is looking at BNS.
No, this section 11.
Yes,
It
my
is
lord.
punishable in the case of first offense with fine which may not extend to ₹10, but which may extend to 50, and in case of second or subsequent with 3 years of previous offense with fine which may.
Yes.
So there needs to be somewhere something. Oh, here we get nothing in this section shall apply to dehorning the cattle, destruction of stray dogs in lethal chambers, extermination of or destruction of any animal under the authority of law. Now, what do you say about cattle? In Assam, we have a Cattle Preservation Act. Prevention of cattle, some prevention of cattle slaughter act or cattle preservation act, I think.
Yes.
So there you cannot kill cattle like that unless it is being permitted and all these things. Now, unless there is an act in that regard, can the state impose such a ban which is there in respect to other states which are there?
Milords, for a moment, in 11.1, Milords, your lordship will also kindly see 11.1L. Which deals with, Milords, mutilates any animal or kills any animal, including stray dogs, by using the method of strychnine injections in the heart or in any other unnecessarily cruel manner. And
So
this, Milords, is...
therefore you have this, the exception is being given out there at 3C, 3B.
3E, Milords, I think it is, Milords. 3E.
3B. The destruction of stray dogs in lethal chamber is an exception. Section 11(3)(b).
Yes, Milords.
So therefore, my question is, without there being an act brought in,
yes,
which identifies which are the animals,
yes,
could 4828 and 429 read with section 11
Yes.
of the Prevention of Cruelty Act be issued in respect to the dogs in question? More particularly, when this particular notification, which is mentioned, which forms the basis of a notification issued by the FSS, that is 6th of August 2014, stipulates only slaughtering of animals of any other species to be a violation of the FSS Act and the regulations.
Your Lordship is right on the question. I may put it in another way, my lords. This is not a question that has been dealt with by any of the judges.
That is one thing. And in fact, Justice Fukan went
Yes.
into another aspect, that when they raised the issue of Article 371A, Justice
Yes.
would not look into that very aspect.
Yes, he didn't. my
As
lords.
Justice Fukan, while going into 371A, submitted that the petitioners did not raise that issue in their writ petition.
Yes, my lords.
Prime reason. But taking into account, madam, you see, we are in an intra-court appeal,
Yes,
not
my lords.
a direct appeal, not an
Yes.
statutory appeal, it's an intra-court appeal. So
Yes.
what least was before the learned single judge on an intra-court appeal being taken up by the division bench,
Yes.
is the division bench is also looking into the same list which was there before the single judge.
That is true, my lords. But this list of 371A was not before the single judge, not argued, not urged, not pleaded.
Maybe, but then also it is a question of law, don't you think, madam?
Of course, my lords. That I'm not disputing. I'm just putting before your lordship the fact that single judge, this was not the issue. Now, my lords, if my Lord Justice Fukan, as your lordship said, my lords, being an intra-court consideration, my lords, in this matter, my lords, what happens is Justice Fukan has not taken a view on this subject, rightly or wrongly, my lords. So that is the view. As far as my Lord Justice Habong is concerned, he has taken a view. So, my lords, this is the position as it stands. So, my lords, also the fact we are going, my lords, from maybe one possibility to another. So, my lords,
Madam, can we do one thing?
yes.
Can we ask the parties to file pleadings on 371A?
We had filed them. They were so filed.
On 371A?
Yes, yes. So they were filed.
You have filed pleadings?
Not here, my lords, not in this. They were filed before the appellate court, my lords.
No.
An affidavit was filed, my lords.
Did you file the affidavit of 371?
No, not specifically.
That is not there.
No.
371A is an issue which ought to have been taken into consideration in the proper perspective. Because recently, Madam, we
Yes.
were another interesting aspect which needs to be taken.
Yes.
You see, 371A and 371G.
Yes, my lords.
G is for Mizoram, 371A is for the Nagaland, state of Nagaland.
Yes. Yes, my lords.
Arose as regards acquisition of land.
Yes.
Now the question is whether the right to fair compensation, which is the 2013 Act,
Yes.
applicable in the state of Nagaland or in the state of Mizoram.
Yes.
The court held that it is on a different entry. It is nothing to do with lands, because otherwise lands, in respect to purely of lands, it is not there. It is barred unless the resolution is adopted by the Legislative Assembly. But however, when it is a case of acquisition, which is a different entry in the list, in the various lists of the 7th schedule, the
Yes.
held the 371A or 371G would not apply. So we need to find out on that aspect or in that angle as to whether the FSS will be there. Now, FSS only says not to slaughter in that notification of 2014.
Yes.
FSS does not say then don't eat.
Because FSS says that only food can be eaten.
Understood. What are the food?
So what is not food? I'm sorry, Manoj, I thought I interjected. I'm
Well,
sorry, Manoj.
here it says
Yes.
slaughtering of animals of any other species other than one listed above is not permissible under FSS Act and regulation. Now,
Yes.
FSS Act does not specifically mention about slaughtering, but you say, as you say, that the rule says about slaughter.
Yes. Yes.
And you also say that slaughtering means eating. But wherever,
Yes, Manoj.
but however, the matter before this court, or that matter which was the least in before this court, was 4/7/2020,
Yes, Manoj.
wherein there was a direction for stopping commercial import and trading of dogs in dog market.
Yes, Manoj.
That does not fall within the purview of FSS. Because here eating doesn't come till now. B. Commercial sale of dog meat. Yes. Here FSS may come in.
Yes.
In markets and dine in the restaurants, B may come in. But A would not come in.
Plus, we'll also look into this, though, again, as I said, this part has also not been considered by any of the judges.
So A would not come under FSS. B may come under FSS provided FSS is not required under 371A.
Of course.
Now, secondly, 428 and 429, as well as the prevention of section 11, would
Yes.
not have been brought in, which apparently appears to be something wrong because it would encompass all animals. Unless the state says, by way of a law, that this is not, dog meat is, there's a prevention of killing on bad dogs. That has to be a law.
Well, Manoj, I would prefer to reserve my submissions on this till I reconsider these, Manoj, in the light of what your lordship has said, Manoj. Because some of these issues were not raised as such by any of the judges, and I was believing that your lordship might consider, as your lordship said, to take the views of either of the judges under section 98. But Manoj, I will look at.
Madam, I
Yes.
say, here I am, if I take 98, I have
Yes.
the option of looking into the point of law.
Yes.
And law being, which my view, which is, when the
Yes.
lease was before the learned single judge, the lease being an intra-court appeal is also before the division bench. And when the lease is before the division bench, now I act as one of the judges of the division bench. And therefore, if it is a question of law, I can very well look into, not a question of fact.
No, your lordship is, I mean, generally correct, Manoj, but section 98 seems to limit it. May I just, for a moment, show your lordship section 98? In fact, when we were considering the manner of submission also before this court, Manoj, we were considering to what extent we would look into each of these issues. But how's section 98, if I may read, Manoj?
Yeah. Yes.
And there are no high court rules, as your lordship said, Manoj, so therefore I believe it will be 98 which will prevail. So, Manoj, subsection 1 says, where an appeal is heard by a bench of 2 or more judges, the appeal shall be decided in accordance with the opinion of such judges or of the majority, if any, of such judges, which is not the case in the present case, Manoj. Where there is no such majority which concurs in a judgment, varying or reversing the decree appealed from, such decree shall be confirmed, provided that where the bench hearing the appeal is 3, composed or 2 or other even number of judges belonging to a court consisting of more judges than those constituting the bench, and the judges composing the bench differ in opinion on a point of law, they may state the point of law upon which they differ, and the appeal shall then be heard upon that point only by one or more of the other judges, and such point shall be decided according to the opinion of the majority if any of the judges who have heard the appeal, including those who first heard it. So, my lords, it appears that what has been stipulated under section 98 is if the learned two judges, my lords, differ, then your lordships will look at the points of law in difference between the two, my lords, and then take a view one way or the other, in which case it will become a majority, either for or against. That is the purport of section 98 as we see it, my lords.
No, the problem is, you see, it was the duty of either of the judges or the joint judges together to formulate the questions on which.
That is correct.
That having not been done.
Yes.
So, the Chief Justice on the administrative side ought to have looked into it. In my opinion,
yes,
it would not have come into the picture. It would be a case which will come taking into account that we follow the latest Patent Act. It should
yes.
be Patent Act which should have been referred to. Very
yes.
specific stipulation when there are two judges. If you see that, I think it will be the clause 15 of the latest Patent Act, insofar as the Kolkata High Court is concerned.
Yes.
Madam, the Assam High Court order of 1948, it categorizes, more particularly at clause 6, if I am not wrong. That
yes.
was all the basis on which the Kolkata High Court was established. That would be the basis for the High Court of Gauhati. So therefore, you have to bring in clause 15 and the reference should have been made under clause 15. And thereby it opens up for this court to look into also facts of question of facts in the law. Be that as it may, the reference, whatever may be made, there is a, whether it is made under 98, but the law is there, which is clause 15 of the latest patent act, the latest patent. So therefore, I will have, whether the reference has been made by the administrative order would not circumscribe the jurisdiction of this court if this court have the jurisdiction in terms with clause 15.
Very well, because we'll definitely look into that also, my lords. And in any case, my lords, your lordship has put up some questions, my lords, also for consideration. So we'll look into those. We'll file necessary affidavit of pleadings. Yes.
Also look into the fact that whether the notification under that is section 47/2020.
Yes, my lords.
Being an executive instruction can also be considered to be law under Article 13 for the purpose of putting a ban on sale. Because that power would be there with the state, irrespective of the FSS Act, to do so. That is another line which you may think about.
We will, Manoj. As I said, because we had thought we would present the matter in light of the views taken by the learned courts, the judges, my lords, and no doubt these are some of the issues. So we look into this, and this is a line, my lords. Obviously, the state's power always extends beyond the legislative, my lords, intent also. Scheme. Yes.
The state out here would have the power which is reserved in the state list to prevent for preservation and from or slaughtering of animals apart from the state, apart from what the center may say so. But the state have the power because public health also comes within the entry of the state list.
Yes.
Okay.
Because health actually always does, and your lordship is right, state subjects always include the subject of public health, even though the center also has, my lords, its own.
Okay, then we do one thing. Only thing is now I'll have to carry this file back to my principal seat. I actually don't belong from this seat. We will do one thing. I'll carry back here. When do you want this matter to be listed?
Lords, I would need a little time because of this consideration. So I was wondering, may I just ask my colleagues what they could do?
Yes.
I'll take a second. Samrat, what do you suggest?
Second week of July.
Okay.
2nd of July, second week of July, we are on vacation. Those.
Oh, I
okay.
see. So, my lords, so till when, my lords, your lordship is on vacation? My lords,
We
I'm sorry.
are on vacation till 12th of July.
Very well, my lords. So then, my lords, you could have it after 12th of July, my lords, at your convenience, my
And
lords.
we will be sitting in the principal seat, then you have to take it up on a Tuesday or a Thursday.
Very well, my lords.
Tuesdays and Thursdays are hearing days.
14 July, your lords, my lords.
Okay, 14th of July.
That's a Tuesday.
Okay. Heard.
And
The Learned Senior Counsel, assisted by Mr. S. So-and-so, the Learned Counsel, appearing on behalf of the appellants in the present proceedings.
this is in the writ appeal 7, and there is a connected, my lords, matter also, in which we are for respondent number 9, I believe.
9.
Yes.
And you are appearing for respondent state?
No, for the respondent 1, 2, 3 in WA7.
Mr. Ali Ralu appears on behalf of the respondent numbers 1, 2, and 3. Ms. B. Sukru appears on behalf of the additional advocate general, appears for the state of Nagaland. This court have heard the counsels at length on the various issues, including on the various law points. And there would be a further necessity of hearing. Accordingly, list this matter again on 14th of July 2026. This court further directs the registry, this court directs the registry of the Kohima bench of the Gauhati High Court that in the circumstance, I am not sitting in the Kohima bench on the said date. Scanned copies of the records of the present proceedings be placed before me in the principal seat of the Gauhati High Court. And the present proceedings shall be conducted to the video conferencing mode. List accordingly.
May I be permitted to submit? May I be permitted to submit a written submission?
Whatever you, all councils, all the respective parties are permitted to file written submissions if so advised.
Grateful, my lords. Unless any time your lordship is fixing it for or the regular time.
Here, madam, we have luxury in Kohima, but not
in Calcutta. Very well, my lords. We'll mention in the morning. Grateful.
other matters are there. Yes. So let me come back. Take up the other matters. You take up that issue which I have taken up. Think about this. These are very essential issues.
We'll do that.
Okay. Good, okay. You also think about whether it would be an order, whether that order would be a law under Article 13, 47/2020. And if that is a law, there can be a power, because I think the state has the power. You see 161, Article 161, it says the power of the state is coterminous with the power. When there is no law, the state executive has the power.
Order 12. Sorry. For orders, item number 12.
My lord, as pointed out by the counsel for the respondent number 3 on the earlier date, the petitioner herein have filed an appeal before the appellate authority of the Income Tax Department, which is yet to be disposed. As such, I pray that I may be permitted to withdraw the present writ petition with liberty to file afresh if my appeal is not allowed, my lord.
No. When you file an appeal,
My lord.
an appeal lies before the appellate income tax appellate tribunal.
My lord.
Against that order of the income tax appellate tribunal, which is under 256.
My lord.
And appeal lies to the High Court, to the division bench.
My lord.
So you are now he is now in 256, no? Mr. Setia?
My lord, its appeal was filed under section 246A, my lord.
So he is
It's
filed
before
under 256A. Then
Lordship.
against that, an appeal lies under 256.
Lordship, I'll just.
Appellate tribunal.
Yes, lordship.
And thereafter, a reference or an appeal lies to the
High Court, lordship, under section 260A.
268.
Lordship.
So you come to us later on.
My lord.
After
My lord.
going through two.
My lord, my lord.
And then come, not now.
My lord, my lord. But at least, my lord, if that liberty can be pointed out, otherwise.
Not necessary. Your person who has filed the appeal, he knows.
My lord, these are not legal persons, my lord. They are not legal persons, so they are, in fact.
Whoever has filed the appeal before
Totally
the
unaware, my lord.
appellate tribunal,
My lord.
appellate authority knows what is needed.
My lord, my lord.
Mr.
Otherwise,
Senator, the learned counsel appearing on.
I'm worried that if tomorrow, if the order passed today is shown, and if in the later stage, if I have to approach this honorable court, the division bench of this
Let him go.
then
You will go as per law.
then if this
Let it say
today's
that the withdrawal of the instant petition shall not prejudice the petitioner to avail other remedies available under law.
my lord, then that is sufficient, my lord. I'm obliged.
Santianga, the learned counsel appearing on behalf of the petitioner. Mr. S. Setia, the learned counsel, learned standing counsel for the income tax department appears. Also, I also heard Mr. S. Setia, the learned standing counsel of the income tax department. The Santianga, the learned counsel for the petitioner submits that as the petitioner had already filed an appeal before the income tax appellate authority against the assessment order dated
19 February 2024, my lord.
19 February 2024. The petitioner herein would not like to further pursue the instant proceedings. He, however, submitted that the withdrawal of the instant petition should not prejudice the petitioner in the appeal so filed before the appellate authority or in further pursuing remedies available under law. Taking into account the above, the instant petition stands closed on withdrawal. So it is observed that the withdrawal of the instant petition shall not prejudice the petitioner to in the appeal filed before the appellate authority, as well as in pursuing other available remedies provided under the Income Tax Act 1961.
Lordship, interim order to be vacated, lordship.
Orders passed, yes, that's vacated.
Deeply obliged.
I am obliged.
For orders, item number 13.
Yes, what is this?
Your Lordship, I'm appearing on behalf of my senior counsel for the petitioner.
Who? Appearing on behalf of
Petitioner.
petitioner. Yes, tell me what is it?
As per the court order
What is
dated
that case about?
0705-2026. We have already filed our affidavit. However, my senior is indisposed, so Lordship may kindly list the matter for hearing after 2 weeks.
Madam, you submit it. You don't submit in this manner. No? Gujarat. Heard Miss So and so, the learned counsel appearing on behalf of the petitioner. The learned counsel drawing the reference to the affidavit filed on 25/5/2026 submitted that the paper publication has been carried out in the newspaper Sundays Gujarat Daily. The learned counsel further submitted, sir, Sundays the Gujarati Daily in its edition dated Three 5/2026. This court, having taken note of the said newspaper, which the original copy of which have been enclosed as Annexure 6 to the petition, to the affidavit, as well as the advertisement at page Roman 3, is of the opinion that the service upon the respondents are complete. Service upon the respondent number two. Respondent number 2, na? Respondent number 2 is complete. Who appears for the State Bank of India here? Any counsel? Mr. Sankar?
Your Lordship, I'm not well versed with this case.
Accordingly, list this matter for admission on July 14th, 2026. In the meantime, this court further directs, in the meantime, we have it earlier. Somebody has filed an affidavit, na? Okay. We have it early. Yeah. List this matter on 15th of June 2026 for admission.
Much obliged.
For hearing item number 16.
What is the matter about, madam?
Lordship, through this instant petition, Lordship, the petitioners herein are praying for claiming land compensation, Lordship. Now, they are impugning one letter, Lordship, dated 14 December 2011.
December
2011, Lordship. Page 1446, Lordship. 146, Lordship.
What is this?
No, Lordship, in this letter communicated to the Chief Engineer, Lordship, Ministry of Road Transport and Highways, the respondent number 5 has written that in Nagaland,
Page 144.
146, Lordship. In fact, it's repeated, Lordship. It's repeated. 146,
Latest
Lordship.
status of 7 mega projects.
Yes, Lordship.
Laning of Longlang Chongtagiaro. Government of Nagaland has decided to give land free of cost for the development of so and so kilometer length of roads under demand in the state, and acquisition of land does not arise. These projects do not pass through any reserve forest, and hence forest clearance is not required. Then
No, Lordship, now the petitioners herein, there are 17 of them. Initially, during the pendency, Lordship, of this case, 3 has dropped, but they have already entered agreement with authorities concerned, Lordship. So now, these petitioners, the rest of the petitioners, 14 petitioners now, they are private loan owners, Lordship. And the land belongs, these are the land they have invested, Lordship, with all the lifetime saving, though the cost is not much.
so your land is taken over.
It is, Lordship, it is. Now, Lordship,
How do you know that your land has been taken over?
even it's there in the affidavit, Lordship, filed by the state respondents, Lordship.
1, 2, and 3.
Yes, if you see the latest affidavit that is 31st January 2025, Lordship, there also assessment was done, verification was done, and they have given the enclosed report also. There,
31st January 2025.
Lordship, yes.
Filed by?
By state respondents.
What does he say? That a survey was conducted solely for the purpose of demarcating land with and not for a reassessment of the land for development. The demarcation was carried out at on the request of the petitioner and to prevent any potential confliction of the land.
If you see page 27 of the affidavit, Lordship,
The latest office report out of 17 people have claimed and received the compensation. Therefore, the survey conducted was whether the land was within the ROW. Now, what is their stand? Does it fall within your land, ROW?
yes, Lordship, page number 27 of the affidavit is the land measurement taken, Lordship, wherein our lands are affected, Lordship.
Survey of land and the changes so and so. Required area under the railway, changes numbers so and so. Your names are there,
Lordship, yes, these are our names, Lordship.
1 to 13.
Yes, 1 to 13, Lordship.
Where are your names? And now they don't want to pay you compensation.
No, ma'am. If I may be allowed to make my submission, at the time of my submission, I will come to the.
Yeah, but she was making her submission.
Yes,
So
ma'am.
now I am asking you, so you will obviously get your right now. Make your submission, Mr. Sant.
My lord,
Are you making compensation to these 13 or not?
the present writ petition is being filed by 17 of them. Out of 17, 2 of them has already obtained the compensation. We are ready to pay, but they are not coming forward.
No, Lordship, that is
15
not
of
the
them are
case.
not
Do
coming.
one thing, no, very well. You do one thing. You pass an award.
Yes, ma'am.
You acquire the land and pass an award.
My
Hand
lord,
over.
if I may be allowed,
Mr. Sankam, let me tell you. What is your power to take over somebody's land?
my lord,
What is the power? How do you exercise that?
in the state
You
of
exercise
Nagaland,
the power either under the Nagaland Land Requisition and Acquisition Act 1965
yes, ma'am.
or under the Right to Fair Compensation Act,
We are yet to adopt.
or whether you adopt or not, that is not required under 371A. That is another aspect. You don't require it to be adopted. in view of the division bench judgment or under the Land Acquisition Act. Okay?
Yes, madam.
Now, unless and until you don't go ahead and acquire the land
Yes, madam.
and pass an award, giving them an offer that look here, this is the amount, you take it.
Yes, madam.
And then whether if they don't come, you deposit in the court this amount. The land is yours, take over the possession. But why are you not doing that? You don't have the right, you don't have the executive faith just to take over the land as per what you wish.
My lord may have the rough idea about the Nagaland state. We are still between Dimapur to Kohima. Under such dilapidated road conditions, the people of Nagaland are traveling. The rest of the state, connectivity between the district headquarters, unless we take up in a very speedy manner about the road
You have
connectivity.
the power under Nagaland Acquisition and Acquisition Act. It's a very speedy manner. You just issue a notification under section 4(6), take over the land.
Yes,
Matter
madam.
over.
However, we are only a supervisory agent. The main employer are the MORTNH.
So therefore, MORTH or whoever it is,
They are also made as a party here.
it's the council. MORTH is the beneficiary. Power is you. You have the power. The collector has the power. The collector will exercise the power of taking over because the authority has been given by the act upon the collector.
Lordship.
And that authority, the collector has the power to take over the land and give it to them. And they will pay the compensation to you, you will pay the compensation to them.
If
That's
a
it.
direction is passed,
No, that is the simple aspect.
if a
You can't
direction
help
is
it
passed.
with any other aspect. There's
Yes,
no
sir.
question of somebody, because if Mr. Santam, the problem which will happen here also in Assam, we have an Assam Mala policy.
Yes, ma'am.
Now that Assam Mala policy has been done in terms with section 46
Yes.
of the right to fair compensation.
Yes, madam.
You don't have a policy to that effect. Because you see, if you see 103 of the right to fair compensation, it categorically say that the state can have any other schedule or any other compensation package which is better than which is given under the Right to Fair Compensation Act.
Yes, ma'am.
So therefore, they have made under section 46. But you need the power somewhere. Now tomorrow you have paid. Just for example, let us assume you go and you have paid them this particular amount to those two. You have paid. They have accepted. That is not final unless you buy it from them. How does a sale take place? Either you purchase it right away. Okay, we don't acquire, we take over the land from you. We'll execute a sale deed. That is very well, you can do it. But the other thing is by way of an acquisition. If you don't have an award in respect to those also, those two also, you will be in trouble later on. Not today, another 20 years down the line. I've seen in many matters, 74, 75 payments have been made. In 2020 or 2013, they filed with petitions. Then look here, there was no award passed. No, nothing. Without an award, nothing happens. Now, after that, when we ask the authority, those officers are gone. They may have some agreement to that, but that agreement is not recognized under law. So when you take it up, we have to say that, okay, acquire it. When they acquire it, it's a huge amount. So what do you do as regards those two also? You have to pass a consent award that this is the amount they have agreed, we have paid, and this is the amount which we have taken. Matter over, you see section 9 of the 9(2) of your requisition and acquisition act, section 9. You don't have that?
Section 9. Yeah. Right. My lord, before coming to a conclusion, if I may be allowed to draw your lordship's attention to my para 4
Of this affidavit.
of my affidavit.
This affidavit, I've read it.
My lord, I'm sorry, para 3 of my affidavit in opposition. May I read, my lord?
Yes.
That the deponent begged to state that the survey was conducted solely for the purpose of demarcating land with the right of way and not for the reassessment of the property or land for damage compensation. The demarcation was carried out on the request of the petitioners and to prevent any potential complications or confusion arising from overlapping or unclear boundaries. It is to state herein that, as per the Honorable Court's order dated 21/11/2022, 23/1/2023, and 14/2/2023, Bas in ISC Bill 130/2022, linked with WBC number 1213/2021, J and 16 others versus the state of Nagaland and 6 others. A joint inspection and verifications were conducted as per the circular issued dated 7 March 2023 at the petitioner's land, which determined that the reassessment for the damage compensation of the properties was not feasible since all the properties in the area had been removed due to the ongoing construction activities. Therefore, the previous assessment for damage compensation was fixed after following due procedure by the district administration in coordination with NHIDCL and other line departments. It is therefore the damage compensation fixed in the instant case has attained finality, and moreover, reassessment for the damage compensation is not possible as the project work is in advanced stage. It is also pertinent to state herein that the deponent was in receipt of the letter from the landowners requesting the authority for a comprehensive survey of land and property earmarked for acquisition of the Mon Tamlu Merangkong Highway prior to commencement of work. Accordingly, the deponent issued a circular dated 15 December 2023 by informing the members of for a joint survey to be convened on 19 December 2023 for a comprehensive survey of land at JNH such and such Mon. Accordingly, a survey report dated 17 January 2024 was issued, wherein it has been specifically mentioned that the details of land falling within ROW in the said JNH and the corresponding measurements were recorded, and moreover, the landowners also agreed with the joint survey conducted by the authorities by approving to proceed the work within the earmarked ROW. Furthermore, the landowners were insist of the matter with regard to the issue of land compensation, which is pending before the Honorable High Court Kohima bench. Therefore, the survey conducted on 19 December 2023 was only with regard to as to whether the land falls within the ROW and not otherwise. In addition to that, as per the latest office record, out of 17 beneficiaries, two beneficiaries have claimed and received the compensation. Para 4, that this affidavit is filed bona fide and in pursuance of the Honorable Court's order dated 13/5/2024 by bringing on records the present status, my lord.
No, Lordship, allow me to.
Mr. Sankam,
Yes,
you
ma'am.
admit from this affidavit that the land of 13 petitioners fall within the ROW.
Yes, ma'am.
You admit that 2 of the petitioners have been paid the compensation.
Yes, ma'am.
You also admit out here that this joint survey was carried out only for the purpose of finding out as to whether within the ROW, the land of the petitioners are there.
Yes, ma'am.
Mr. Sankam, I understand everything. My question is therefore very simple.
Yes, ma'am.
How do you get the right over the land? The land has to vest in the state. Either you have to purchase it by way of a sale deed
Yes, ma'am.
or have to acquire it.
Yes, ma'am.
Now, if we have not acquired it, the land is always theirs.
Yes.
Tomorrow, when you make the road, they can very well stand out there and say, this is my land, kindly. Anybody crossing this land would be mine. Saying similarly, like the Strait of Hormuz. Huh? Tomorrow, madam can do it. My question, therefore, is you have to. So, therefore, kindly see line 2. Line 1 and line 2. You exercise that power. Every day in the principal seat, I take up 70 matters. Out of the 70 matters, 20 matters are like this. Every day.
My lord.
So therefore, this, you see, if I'm not wrong, section 3 is for requisition. Section 6 is for acquisition. Section 9 is urgent. Exercise that. Pay him some money and pass an award. Once you pass the award, if they are not accepting it, they will go to the reference court under section 12.
Yes, ma'am.
Why are you waiting for all these things and fighting out a litigation from 2021? It's a simple matter.
Lordship.
2 of the beneficiaries have already.
Lordship, we're not denying that.
There also, Mr. Sanktam, you have a problem. You say they have accepted.
Yes, ma'am.
Now, tomorrow, what happens?
Yes, ma'am.
If they have accepted it, how do you get the land? The land has to vest upon you. You see section 9.2, read it. 9.2 or 9.3, if I'm not wrong. Once that notification is issued under section 9.2, the land will vest in the state. So the vesting is required to be given it to them. You can give only your land, you can't give madam's land. Isn't it, Mr. Jamil?
State, we are only a facilitator.
Understood. So therefore, you put a proposal to them.
My lord.
That look here, this is the land we have to acquire.
My lord.
From these documents.
My lord.
And therefore, kindly, we will do it, provided you deposit. This is the amount which we think is the compensation payable.
My lord.
And thereupon you ask them that kindly provide the proposal. Once you provide the proposal, they will provide you the amount. Once they provide you the amount, and on the basis of that, you initiate the proceeding. In the meantime, you initiate the proceedings under 9.2 and pay them. The problem is, once you take over the possession, then if you go as per the old act, you have to pay compensation, the interest under section 34. So therefore, you immediately take up the steps.
In
You
good
cannot
faith,
confer.
my lord, in 2011, in good faith, the government of Nagaland had proceeded that with the consultation of the tribal hosts. After obtaining NOCs from all the tribal hosts.
There are many cases where, I tell you one thing, while sitting out there in Arunachal bench, we get a lot of matters. Most of the land, if you go to Pasighat, you go to places like Tezu, you go to places like even Nagaland, and many other centers. All these lands were donated for the purpose of bringing within the town a township by the people. All the people donated, joined together. And after donating all this land, they became the land of the state. Now, thereupon, patta is only given within that donated lands, which becomes the state's land. Because in Nagaland, you go to Arunachal, the land belongs to the people.
My lord.
Not the land doesn't belong to the state.
No.
Except the reserve forest, it's a different aspect of the matter. Once you reserve it, it's a different aspect. So therefore, you need to But now these things have changed. Money has come into the picture.
My lord.
Everybody needs a fine house, a good car. So therefore, everybody wants money.
My lord.
So you have to do that. 2011, what was Kohima is not today's Kohima.
My lord.
Even I remember my first time I came out here and sat out here on 15th of February 2022. First time. When I sat out here, Kohima was dark by 5:30, 5 o'clock. You don't find any of the any of the shops opening. In 4 years, Kohima has gone from whatever it is, now it is different completely.
My lord.
And with all these commercial things coming in, madam's clients are therefore being jealous of getting those things also.
My lord, everybody needs good road.
Huh?
Every district headquarters connectivities needed to be upgraded
Definitely.
by 2
There's no
lanes.
quarrel. There's no
Somewhere
quarrel with
4
that.
lanes.
But the state also, the state, you see, it is not for you, it is for NHIDCL.
My lord.
Now you see how do you do it? If you have an award, what is the benefits? Once you have an award, there are two amounts you get.
My lord.
One is the establishment charge and one is the acquisition charges. Establishment charges are fixed at 8% of the total amount, and 2% is always fixed. That is a relation between the government of India and the state, and 2% for the purpose of acquisition process. Whatever you do, so you get 10%. The state gets some amount of money, but you're not doing it for the state.
At that relevant point of time, whether or not the Ministry of Road Transport and Highway was forthcoming or not, the tribal hosts were invited, unless we donate land free, of course.
No, that is okay. They
Coming up with
they
2
would
lanes,
like to do
4 lanes.
anything. You see, the law as of 2011 also is a different thing.
Yes.
At that point of time, the court was not so jealous enough to protect the rights under Article 300A. Now, after the judgments in the case of Vidya Devi, the state of Himachal versus Vidya Devi, there the things have changed.
Not sure.
Now, Supreme Court considers the right under Article 300A not to be akin to a fundamental right, but to be akin to a human right.
Exactly, Lordship.
Yeah. So therefore, things have changed. Law has developed.
Yes, ma'am. Yes, ma'am. If a direction is passed by this honorable court, directing the ministry to allocate fund,
Allocate funds means you have to ask them funds. How are you paying that compensation from? From your own pocket?
no, my lord, that is only for damage compensation. Damage compensation.
No, you have said 2 persons have been paid.
Yes, yes, that's
No, you say that out of 17, 2 persons have already been paid.
regarding
Not
that is
ROW.
coming under the purview of damage compensation. ma'am.
Not for ROW.
ROW.
Now, ROW, if it falls within the ROW,
Yes, ma'am.
then it is acquisition. That's not damage compensation.
Lordship, yes.
And acquisition includes the Jirat. The Jirat will be the whatever houses were there.
Lordship, yes.
You cannot do anything unless you acquire. Mr. Muajami, what do you say?
We are only a supervisory agent, ma'am.
You are not a supervisory agent. You are the link between the petitioner and
Yes.
Mr. Muajami.
Lordship, I agree with the act.
You can't do it anything because tomorrow what will happen is you make a construction.
Lordship.
20 years down the line, they will demand.
Lordship.
At that point of time, the road infrastructure becoming better, the price will go up. The thing which was 200 rupees will become 50,000 rupees. That is why while taking up the dog matter, I was saying, animal of 10 rupees and above, could it be there? Now you get everything. You don't get anything at 10 rupees.
Right.
isn't it? So, as regards these 13 petitioners which have been mentioned in annexure what is the survey report is annexure? F. Annexure F, na?
Yes, Lordship.
So in annexure A, you cannot go ahead, you have to pay them the compensation. So therefore I pass an order to the effect, keeping the matter pending, Mr. Santa. In the meantime, you take up the matter with the NHIDCL for appropriate funds. And in the meantime, you initiate action under 9.2. I won't say 9.2 under the appropriate provisions of the Nagaland Requisition and Acquisition Act 1965.
Lordship.
Initiate a proposal. There, for that, you need to move them also that this is the amount which needs to be paid.
My lord, may be pleased to pass a specific direction.
That is what I'm thinking. I'm only asking your concurrence before passing.
Lordship. Lordship, kindly allow me to make a small submission here. On 19 December 2023, 13 of the petitioners' land were verified. However, petitioners number 12 was left out. The reason given was that his land was located in the hilly area, so they could not complete the verification that day, Lordship.
No, therefore the question is if the land falls within the RODF.
Lordship, it is, Lordship, it is.
That obviously, madam, I can't say.
Lordship,
I
yes.
can't say whether it falls or not. Now, one thing, whoever it is,
Lordship.
there has to go for an acquisition proceedings.
Lordship,
under
yes.
the appropriate provisions of law. And for that, any compensation has to be paid. You may very well ask the beneficiary. Beneficiary is them. And thereupon, upon deposit, you initiate proceeding or immediately you initiate and give a report before this court of the so and so. This matter should not have been pending from 2021. It's a simple matter. Isn't it? Heard Ms. Nitu Bhoja, the learned counsel, appearing on behalf of the petitioner. Mr. A. Santam, the learned.
LT Santam for 4, 5, and 6, my lord. LT Santam.
LT Santam, the learned additional advocate general.
Yes, ma'am.
Nagaland. And Mr. Muajami, the learned counsel who appears on behalf of the NHIDCL. For the purpose of construction of the road from purpose of construction of the two-lane, na?
Two-lane, yes.
Two-lane road from Merakong, there's Tamlu, there's Mon Road. Between the chain is 74 plus 00, 80 plus 200 at Long Cape portion. The petitioners claim that their lands have been taken over without carrying out any acquisition or payment of any compensation, which is in violation to Article 300A of the Constitution. In pursuance to various orders being passed, an additional affidavit was filed by the Deputy Commissioner Mon on 31/1/2025. From a perusal of the said affidavit, it is seen that on 17/1/2024, a survey was conducted whereby it was found that in respect to the lands belonging to 13 petitioners, it was found that lands of 13 petitioners fell in the right of way, while under the right of way And the details have been given in that regard in the table, more specifically at page 27 of the said additional affidavit. Be that as it may, it is very relevant to take note of that the respondent authorities, however, have not initiated any acquisition proceedings, either under the appropriate provisions of law or by way of purchase, outright purchase of the lands of the petitioners who have been affected. However, in the meantime, over the lands of the petitioners, constructions have been made, carried out. It is the opinion of this court that the lands of the petitioners being properties belonging to the petitioners, the same cannot be taken away, save by authority of law. This is the mandate of Article 300A of the Constitution. The Supreme Court, in the judgment of the Supreme Court in the case of State of Himachal or Vidya Devi versus State of Himachal, reported in so and so, categorically observed that the rights under Article 300A of the Constitution may not be a fundamental right, but it is akin to human right. It is further emphasized in the same judgment that it is imperative on the part of the respondent or state to acquire such land in accordance with law. Taking into account that there has been no acquisition of land, the action on the part of the respondent authorities violates the mandate of Article 300A of the Constitution. In other words, such actions on the part of the respondent authorities is unconstitutional. Be that as it may, this court duly takes note of that roads have been constructed over the lands of the petitioner. And as such, returning of the said lands to the petitioner at this stage would not be in the public interest. Under such circumstances, there has to be directions passed. This court, in order to protect the interest of the petitioner, have to pass appropriate directions, is required to pass appropriate directions for proceeding with directions for acquisition of the petitioner's land as per the appropriate provisions of law. Mr. L.T. Santan, the learned Additional Advocate General, have referred to the Nagaland Land Requisition and Acquisition Act 1965, which provides a speedy acquisition. He, however, submits that the state, or for that matter, the collector, do not have the resources in as much as such land, the payment to be made to the beneficiaries, that is the petitioners, have to be made from the Ministry of Road Transport and Communication, Road Transport
and
Highways. This court have also heard Mr. Muajami, the learned counsel who appears on behalf of the NHIDCL, as well as for MOT.
Only for elections.
For NHIDCL. Who is constructing those, who has constructed those roads? This court is also of the opinion that mere taking over the lands of the petitioners without following the mandate without following the authority of law do not vest right upon the state to permit the NHIDCL to construct in the road. Accordingly, this court fixes this matter again on 7th of September 2026. In the meantime, this court passed the following directions. Number one, the respondent number number 4, 5, and 6 are directed to take effective steps for initiation of acquisition proceedings against the lands belonging to the petitioners if such lands falls within the right to way of the land of the road which have been constructed. For that purpose, the respondent numbers 4, 5, and 6 shall also take appropriate steps before the respondent number 1, that is the Ministry of Road Transport and Highways, as well as the NHIDCL, that is the respondent number 2, for appropriate funds so that the compensation amount could be paid. This court further observes that the respondents shall also take appropriate, this court further directs in the interim that all the respondents in the meantime shall coordinate with each other and take due steps so that the lands which the petitioners claim to be their lands and are also seen from the affidavit filed by the additional affidavit filed by the respondent number 6 that portions of the petitioner's land fall within the right of way of the land can be acquired. Next, list this matter again on list accordingly for an update.
For hearing, item number 21.
Your matter, I'm not going to take it. You said you are not well till 15th of June. Yesterday, remember?
Yes.
Okay, we adjourn it. Counsel for the petitioner being not well, matter stands adjourned to be listed on 15th of June 2027.
Right.
When